May it please the Lordships, on behalf of Mr. S.K. Medhi, I beg to mention item number 4 with due consent of the respondents.
What has happened to the order dated 19th July? We had directed the government to consider some observations were made. What has happened to that? Let us know first.
Lordship, instructions are still awaited.
Why? Is it rocket science? Simple directions whether they are ready to permit the respondent to build a boundary wall. Where is Mr. Medhi?
Lordship, like his mother passed away, that is the reason he is unable to appear today.
All right. It is stated that the standing counsel, Mr. Sanjay Medhi, is in bereavement, and thus a request is made to adjourn the matter for by 2 weeks. List of 2 weeks as played. List on kar dena iska. 18th October as played.
Lordship, if I may, it can be fixed on 12 October.
12th October. 12th October. Fine.
Obliged.
2 weeks. 2 weeks ho jayega.
May it please your Lordship. May it please your Lordship. I beg to mention in item number 3, Lordship, we are filing affidavit today, your Lordship.
Item number 3.
Yes, your Lordship.
Okay. On behalf of
Mr. K. Chaudhary.
affidavit on behalf of reply affidavit on behalf of the petitioner. It is stated by land counsel so and so that reply affidavit on behalf of the petitioner would be filed today. The same be brought on record. Counsel for the respondents may complete their instructions on the amendments made in the affidavit by the next date, re-notify for admission after 4 weeks.
Deeply obliged.
May it please your Lordship.
Yes.
Lordship, with regard to item number 20, similar situation, Lordship, we were directed to file an affidavit. Respondent 7, we filed the affidavit yesterday, my lord. It's yet to come on record. Lordship, may pick
On behalf of National Medical Council.
National Medical Commission, my lord, regard 7.
Lordship, can you fix the matter on Monday, Lordship?
All right. Affidavit on behalf of the NMC has been filed yesterday. The same be
Yesterday.
brought on record.
Yesterday, my lord.
Has been filed. The same be brought on record. List again on 5th October.
Deeply obliged, my lord. Deeply obliged.
May I please, Lordship, Lordship, with the consent of other party, I beg to mention item number 9 and 10.
Why?
Because, my senior is out of station, Lordship.
It is
So the matter
stated
maybe come up on 4th of
you
October.
represent whom? The respondent or the appellant?
My lord, she represents the respondents, I represent the appellants, my lord.
And counsel for the respondent has circulated an adjournment slip, and counsel for the petitioner does not object the prayer for adjournment, re-notify after 2 weeks.
My lord, there is some urgency on our part since they are the respondents, we are the appellants. Okay, it is on
List
4th
again on
4th of-
12th October. Is it okay?
Yes.
12th October.
Obliged, Lord.
May I please, your lordship, I beg to mention item number 13. Due to
Item
the
number,
13, 1-3.
yes,
Due to the unfortunate demise of the advocate petitioner. So,
the counsel has passed away.
no,
Who has
the
passed away?
father of the council passed away. your
Father.
lordship.
It is stated that the land counsel representing the appellant is in bereavement, and a request is made to adjourn the matter on his behalf. List of 4 weeks as paid.
Lordship, item number
Highly obliged.
13, 14 and 15, Lordship.
14 and 15,
14
yes.
and 15, Lordship, in this matter, Lordship, London Advocate General will appear, Lordship.
It is stated that Learned Advocate General Mr. Saikia would be appearing on behalf of the state in this matter, and a request is made to adjourn, because adjourn the same as he is in bereavement. List up to 2 weeks as paid. Item number 14 only.
14 and 15, Lordship.
15,
15, Lordship, I have the taken consent. Lordship. He has also informed the
all right, 15 also. 15 also, yes, all right. It's a cross appeal only. 2 weeks.
May it please the lordship. But I call it retable today, my lord. May I pray for listing of the matter tomorrow, my lord. There
What is the urgency, sir?
My lord, what has happened, my lord, due to inadequate compensation, my lord, and wrong assessment, my lord. I filed a case in the arbitration before the arbitral tribunal, my lord.
Hmm.
So ultimately, my lord, there was an order passed not to demolish, my lord, and it's followed by subsequent order, my lord, whereby expert opinion has been sought by the arbitrator, my lord.
Hmm.
So against both the order, my lord, writ petition has been filed by NIJDCL, my lord, before this honorable court, despite the provisions of appeal under 37 of arbitration and conciliation is there, my lord.
Hmm.
So the learned single judge, my lord, has passed an order staying that part of the order, my lord, to demolish part, state, my lord. So this applicant before lordship has filed an interlocutory application, my lord.
Hmm.
So interlocutory application was not considered, my lord, dismissed. Against that order, my lord, we have preferred.
You are not a party in the writ proceedings.
Yeah, we are the party, my lord. We are the party in the writ
Oh,
proceeding, my lord.
Let,
So, my lord.
let it come up tomorrow. Let
Oblige, my lord.
Yes.
Please, Worship. I'm praying for list of writ appeal tomorrow, my lord.
What is the urgency, sir?
I lead on 19th.
What is the urgency?
My lord, I was selected by the APSC.
Hmm.
However, my result was withheld.
Okay.
After we came to learn that I belong to a category of persons whose results were declared. However, subsequently on re-verification, I was found that I did not qualify in the prelims.
All right. List tomorrow.
My lord.
Daily list for orders item 1.
This, there is a statement, there is some matter pending before Supreme Court.
Yes.
What is that matter?
Regarding the citizenship
CAA.
yes.
Okay. This court is apprised that the matter pending before Honorable the Supreme Court involving analogous issues to one which have been to those which have been raised in this writ petition has still not been decided. Thus, consideration of this writ petition is deferred by 10 weeks. Writ petition PIL 10 weeks awaiting outcome of the matters pending before Supreme Court. 10 weeks.
In this case, the other reliefs are also sought. In this respect, the affidavit has not been filed by the respond number 1, 2, and 3.
Why do we need affidavits in piecemeal? Let the matters be decided, then we'll ask them.
Yes. Much.
Item number 2.
But I'm repeating, respond number 13 has to be sourced from NF Railway.
Who is there for the appellant? Your appeal has to be dismissed for non-prosecution. You have not deposited the cost. The order was passed on 7th December.
We will submit the cost during the course of the day.
Why it took you almost 10 months?
The matter was handed over to us this week only.
What's your good name?
As Yasmin.
S. Yasmin.
Yes.
And Counsel MSc S. Yasmin. You appear on behalf of whom?
Mr. Mukesh Sharma, M. Sharma.
M. Sharma was appearing even on 7th December. Don't make a misstatement. You're a new entrant to the bar. How can you make such a statement? It is his attendance which is marked in the order dated 7th December. Then your appeal has to be dismissed now for non-prosecution. Yasmin, submit that owing to inadvertence, the cost to the tune of rupees 2,000 could not be deposited. She assures that the cost shall be paid to the opponent during the course of the day. Upon the cost being paid and the receipt being filed, the delay in filing the connected writ appeal shall stand condoned in terms of the order dated 7 December 2022. However, in case the cost is not deposited by the end of the day, paid by the end of the day, the cost is not deposited by the end of the day and receipt is not filed in the registry by tomorrow, that is 28th September, the instant writ appeal shall stand rejected. The instant interlocutory application / writ appeal shall stand rejected for want of prosecution without further reference to the court.
Much obliged.
Deposit the cost, pay the cost today.
Yes, sir.
Item number 5.
May I please your lordship? Lordship, in this matter, service upon respondent number 3 is awaited, Lordship.
Awaited.
Yes.
Await return of notice issued to the respondent number 3 for 6 weeks. It's a matter of spending 10 months, that's all.
Lordship. Deeply obliged, Lordship.
Item number 6.
Please, your lordship.
Mm.
Lordship, kindly pass over this matter for the time being, lordship.
We don't have any objection to the delay of it.
IA delay 59 days condone. Writ appeal be numbered and listed for admission.
My lord, that copy may be supplied.
Just hold on.
Of
This
the
is the writ appeal. The number हो गया क्या? Which is this? Oh, no. 6 number. 6. IA allowed. Copy of the writ appeal shall be provided to learned counsel for the respondent.
Lordship, we have filed one IA also, another IA for staying the order.
Without the writ appeal being numbered,
No, lordship.
then
So lordship, we like to place certain judgments with regards to consideration of the prayer for.
all right, we'll issue notice in your IA then. All right, issue notice of the IA for condonation to the respondents.
No,
We are condoning the delay, let the writ appeal be numbered, then only we can consider your prayer for stay.
Lordship.
Numbered and listed for admission on 4th October.
Item number 7.
May please, Lordship.
Mm.
Lordship, on the earlier occasion, my lord wanted to see the application that has been filed by the appellant for compassionate appointment. We have filed an additional affidavit yesterday, my lord, that is not on record.
Is it there? You filed it yesterday
Yesterday, my lord. Additional.
and counsel for the petition submit that he has filed the application
Additional.
submitted by the petitioner seeking compassionate appointment with an additional affidavit yesterday. The same. Be brought on record, re-notify after 1 week.
My lord.
Obliged.
Hello, sir.
Item number 8.
Yes, please.
My lord.
Jurisdiction.
My lord, the fact of the matter is that the notice inviting tender was issued from Guwahati.
That doesn't give you the cause of
My
action.
lord, the successful bidder was from Tamil Nadu. The work was.
Work was done in Odisha.
Absolutely, my lord.
How the Guwahati High Court has
My lord,
jurisdiction?
I'll come
Yes.
to that, my lord. Now, what has happened, my lord? Once he becomes a successful bidder, work order was issued from Guwahati. After issuing the work order, the agreement was executed. In that execution of,
Where was the agreement executed?
my lord, that was executed in Odisha.
The simple issuance of work order, those are clerical jobs. The clerical jobs being done from Guwahati would not give you.
My lord, the payments were also issued.
That is now pan-India, payments can be issued anywhere. That again, NI Act, you see, analogous situation. Mere place from where the notice is issued, doesn't give you the cause of action.
Apart from that, my lord, what happened when they triggered section 18, they issued notices to us at Guwahati.
Obviously, where else they could have done?
They could have issued it in our office at Odisha. My lord, my right has been infringed.
Go to the appropriate high court.
My lord, my right has been infringed because what has happened, my lord? The fact of the matter, part of the cause of action has arisen in Guwahati, my lord.
Show us from one judgment by mere issuance of the work order, the cause of action would
My lord,
lie with that particular high court.
my lord.
Let's see.
2014 9 SCC, my lord.
Let's see. What is the judgment? Zenabi. Yes, please.
My lord, para 16, my lord.
Hmm.
Page 340. Regard being had to the decisions made herein above, there cannot be any doubt that the question whether or not cause of action wholly or partly for filing of writ petition has arisen within the territorial limit of any high court has to be decided in the light of the nature and character of the proceeding under Article 226 of the Constitution. In order to maintain a writ petition, the petitioner has to establish that a legal right claimed by him has been infringed by the respondent within the territory.
So what is the legal right which has been
My
infringed?
lord, I'll come to that. What has happened, my lord? They triggered the MSME Act. Our main contention is that without fulfilling the criteria, you cannot trigger the MSME Act.
You can't?
Trigger the section 18 of the MSME Act.
Mm.
Since we had every right.
MSME Act was to be, the effect was to be triggered where?
No, before section 2B, my lord, says after the appointed date, they can trigger section 18.
But where was it to be triggered, gentlemen? Where
Yeah.
would the effect fall?
No, that would fall in Tamil
So
Nadu.
then that is what the crucial issue is. Either Tamil Nadu or Odisha.
No, my lord, but the fact remains that until and unless my work is completed, you go and ask for money.
That is your relief, what you are seeking. Question, we are
He
simple.
comes under the MSME Act only when he completes the work.
We understand, but
So-
all those parts of the work, where are they being performed? Or where there is an omission? Act, omission, whatever you try to portray, everything has taken place either as per you in Tamil Nadu or Odisha.
Because, my lord, there are three places, Tamil Nadu.
We will issue notice subject to the objection of the respondent. All right,
Your Lordship, I appear for the respondent.
you are appearing for all respondents,
No, Your Lordship, respond number 3.
the contesting respondent.
I'm
All right. Do you have any objection regarding jurisdiction?
Yes, jurisdiction, yes, no, Your Lordship, but with regards to even merits of the case, what is the main contention here is I have completed a particular job
Hmm.
and they have issued a particular job completion certificate, which is at page number 102D.
Hmm.
If your Lordship peruses, this is a provisional job completion certificate.
Hmm.
Now, after I completed job, I was supposed to be paid my full bills. They did not pay them. And in that regard, I invoke the MSME Act, since I am a registered MSME unit.
Hmm.
Now, the MSME Act, if your Lordship peruses to the MSME Act,
Hmm.
it says that for any payment, any delayed payment, the MSME unit has got that particular leeway to get the payments within 90 days. And even if there exists the arbitration clause in that particular contract agreement.
Hmm.
Now, this particular issue as such was under dispute because certain high courts say that the arbitration clause will prevail over the MSME Act and some other high courts say that MSME Act will prevail over the Arbitration Act.
Hmm.
Now, the Honorable Supreme Court, it cleared this whole issue. If your Lordship peruses through page number 222.
All right, what is the jurisdiction of the council? What kind of jurisdiction does the council decide? Their
Where the
their
MSME
contention is that the work was not completed
Yes.
and thus the MSME Act could not have been triggered. Whether the council can decide that issue also?
Yes, Your
Then all right.
Yes, Your
Yes.
Because that is where the dispute rises. They are saying that we have not completed the work. We are saying that we have completed the work.
Let's see what is the jurisdiction of the council under the act.
Yes, para 34
34 of.
of this particular judgment, Supreme Court
Okay.
judgment, page 222.
Hmm.
I'd just like to read out. Chapter 5 of the MSME Act 2006 would override the provisions of the Arbitration Act. No party to a dispute with regard to any amount due under section 17 of the MSME Act would be precluded from making a reference to the Micro and Small Enterprises Facilitation Council, though an independent arbitration agreement exists between the parties. And the Facilitation Council, which have initiated the conciliation proceeding under section 18 subsection 2 of the MSME Act, would be entitled to act as an arbitrator despite the bar contained in section 80 of the Arbitration Act. The proceedings before the Facilitation Council acting as an arbitration tribunal under section 18 subsection 3 of the MSME Act would be governed by the Arbitration Act. And the Facilitation Council institute or center acting as an arbitral tribunal.
Yes, this takes care of the issue. You can raise that objection even before the
Even
first.
in the writ
That
petition,
is not my case.
if I may complete.
Ah, yes.
Even if in the writ petition, their second prayer, which is at page number 63
Hmm.
of the writ petition, there is the prayer in the writ petition.
Hmm.
Their prayer said, a writ in the nature of mandamus should not be issued, thereby directing the respondent number 3 to settle a dispute through arbitration under Arbitration and Conciliation Act as agreed under the arbitration executed between the petitioner company and the respondent number 3. And upon cause being shown, so and so. Now, in this honorable single judge judgment, at page number 311, at para number 7, they have not pressed this particular prayer. They have not prayed for it, that the dispute be settled as per the arbitration mechanism as given in the arbitration agreement.
In any event, Ms. Saivala,
My lord.
after going through your prayer, we are still constrained to observe that you don't have jurisdiction. Sorry. Look at your prayers, please.
No, my lord.
The prayers have no concern with Guwahati. Nothing. The order was passed in Tamil Nadu. The mandamus is sought against the respondent number 3 who is acting in Tamil Nadu.
My lord.
How Guwahati High Court has jurisdiction? Sorry. We'll non-suit you on this ground. Try your luck. Carry the matter further.
May I show my lord one more judgment?
Yes, sure, do that.
What happened, my lord? In one case at Patna High Court, one person was medically unfit. Notices were issued from some other place. It triggered the repudiation of the Patna High Court. It was dismissed. It went to Supreme Court. Supreme Court said no. Since one notice has been issued to the person is
Scenario, what is, which year? The judgment is of which year?
If I'm not wrong.
All these interpretations have been made in relation to the
In that-
amendment in NI Act.
In that,
Things have changed thereafter.
in that case, what happened, Your Honor? The point of jurisdiction has first time been raised because the other side.
We are asking you, gentlemen, you are invoking our jurisdiction. We are asking you.
That is correct.
They may not.
That
We are asking you.
is correct.
Yes. Why this court has this jurisdiction? Or why this court should be compelled to exercise jurisdiction when nothing has happened in the state of Assam?
Part of cause of action.
No part. Look at your prayer. Your prayers are absolutely focused on something which happens in Tamil Nadu.
Because what has happened, this turning of the wheel of section 15 was premature, Your Honor. I come to that. because-
Whatever, you go to the council, raise your objections. Council will take care of your facilities.
They have filed their written statement also there.
You filed a written statement, then why did jurisdiction is being?
It is fixed for hearing now.
We'll decide, all right.
My lord, while observing court may take one point into consideration, my lord.
Yes.
May I read out the page 4310 of the judgment of the single bench, my lord.
Mm.
So petitioner's counsel submit that instead of invoking arbitration clause, the respondent number 3 approached the respondent number 2 under 18(1) of the MSME Act with his grievance on the ground that the contract bill has not been paid despite completion of the work. He submits that a reference under section 18(1) of the MSME Act can only be considered if the provisions of section 15, 16, and 17 of the MSME Act are present. He submits that the petitioner via email dated so and so informed the respondent number 3 that the items which have been delivered by the respondent number 3 in pursuance to the contract did not fulfill the tender requirements.
So even if you see those particular facts, then also supply, non-supply is in Odisha. How we are invoking jurisdiction of Guwahati, sir? Sorry.
Because what has happened, Your Honor, before the appointed date, they have come up.
So all right, you go to the facilitation council. They will take note of your objections. What prevents you from doing so? Take that observation that you will raise all those objections before the council.
No.
You want us to decide the matter in that manner?
No.
All right. After arguing, learned Council Ms. Saivala submits that vehemently and fervently tried to convince the court that the part of cause of action in this case took place within the state of Assam, and hence, the Guwahati High Court has the territorial jurisdiction to consider and decide the writ proceedings. However, on going through the array of parties and the prayers made in the writ petition, we find that the primary bone of contention in this writ appeal arising from the order of the learned single judge dated so and so is regarding the respondent number 1 having triggered the proceedings under the MSME Act by filing an application before the Facilitation Council at Tamil Nadu. Full stop. There is no dispute that the work in question, location of the work in question, which was carried out by the private respondent at the instance of the appellant herein, is in Odisha, in the state of Odisha. Hence, mere issuance of the work order, which is a clerical job from the state of Assam, from the office of the appellant here in Guwahati,
Got it.
in Guwahati, would not give confer jurisdiction upon this court to so as to entertain the writ proceedings as unquestionably, no part of cause of action.
My lord, may I place one more thing? One GCC contract was executed wherein the jurisdiction was specifically assigned. The GCC contract by which the tender was given to them specifically says that jurisdiction is there in Assam.
That clause of the contract is unconscionable or contrary to law.
That is there, my lord.
Then
No,
that you are ousting jurisdiction of Tamil Nadu, Odisha.
no, that
Then-
also, that court also has jurisdiction. My thing is that why should I go to Tamil Nadu, my lord, when everything was done here?
Yes, you have to go. Yes. Faced with this situation, then counsel, Mr. Saiwala submits that since the appellant herein has already filed its written statement in the proceedings before the facilitation council, it may be allowed to raise all permissible objections, including the objection of premature invocation of the provisions of MSME Act by the respondent herein, and the facilitation council may consider such objections as per law. Full stop. We have no doubt that upon such objections being raised, the facilitation council will consider the same as per law. The writ appeal is closed with the above observations.
Item number 11.
Your lordships,
Issue notice to the respondents. Steps for service be taken in 7 days whereafter process be issued. Copies of writ petition be provided to the standing counsel who have put in appearance on behalf of the concerned respondents. Mr. Goswami, Mr. Kalka, Madam Crow, all. Stickers on advocates' vehicles. Another touchy issue.
your lordships, I am the petitioner in person of this PIL.
There is a fact, Mr. Kalita and Mr. Goswami, in Rajasthan, there have been instances of the vehicles with these stickers being used in narcotic transportation.
Yes, Lord.
Many.
I think this is very
It's very relevant.
Your lordship, this very issue was raised before the Madras High Court in the case of
We had the
Ramesh
respondents,
versus
we have issued notice, we have entertained your petition.
Okay.
Yes.
Give us the copies. huh? Yeah, sure.
The bar council will have to be served. Lots.
Item number 12.
Gunaji, mention so and so appear on behalf of such and such respondents. Steps for service on the remaining respondents will take the next. Yes.
My lord, as per the present status of the work, my lord, that is mentioned in annexure A1 at page 249.
Mr. Barwa, last date you said that you wanted to file a rejoinder affidavit.
No, whatever, my lord, your lordship, dispose of the PIL, most of
They
the,
already disposed of.
road projects are completed, my lord.
Then-
As from the record I have seen, my lord, page 249 running.
So
page.
then what do you want now?
My lord,
you may close it.
Close it. And give liberty to the petitioner, my lord, to approach the principal secretary as regard the other maintenance and repairing of the roads.
Mr. Barwa submits that after going through the affidavit filed by the respondents,
Yes.
the petitioner has achieved the satisfaction that most of the roads in question have been constructed. However, his prayer is that regarding the issues of maintenance, etc., and the petitioner may be given liberty to approach the principal secretary concerned as and when the occasion arises.
Secretary PWD also on that. The secretary PWD.
And the secretary PWD as and when the need so arises in view of the affidavits and the photographs attached there to Kardina. In view of the submission so made, the proceedings of the instant PIL 38/2000 are closed with the Liberty platform.
Obliged.
Item 16 and 17.
Can this matter be taken up next month or any date, my lord?
Next month.
Yes, next month be October, my lord.
Okay, very well.
Summer 12th of October, like this.
Yeah, let it go in November then.
Yes. ma'am.
As prayed by Senior Counsel Mr. Das. List on 22nd November.
My lord. Not really.
Item number 18 and 19.
May I please, Lordship? Lordship?
Yes. It becomes easier.
Lordship, my senior is on late. My senior is on late and.
What do you want, madam? You got the original contracts?
Your lordship, so far as first item is concerned,
You already had received it, no?
we have received the second one, your lordship. not
Okay, second
first.
one. First one is not
Not yet.
traceable or what?
They could not find out. They could not find out they are still searching for the original record.
All right. Land Council, Mr. So appearing for the respondent submits. Mr. Andik appearing for the respondent, PNRD submits that the original contract has still not been traced out. He prays for and is granted. Last opportunity to do the needful. Denotify on 8th November.
Obliged.
Name of Mr. Das, M. Das. Shall henceforth be reflected in the contest.
Item number 21.
May it please your lordship.
Cattle market.
Yes, my lord.
Where
The,
is Mr. Nath?
the
Yes.
government has filed an affidavit, my lord, and my basic contention is supported by the state government, my lord. And so far as there are two parts to my petition, my lord. One is that it challenges the acts, which of course the state government wants to uphold it. And the second part of it is that so far as the NOC issued by the deputy commissioner is concerned, that is not in consonance with the act. And on the basis of the NOC, my lord, a cattle market which is not registered under the act which the state government wants to be upheld, my lord. They cannot continue, my lord, the private respondent.
Who's
And-
there for the private respondent?
Private respondent number 6.
Anyone has come in? You are there? All right.
And therefore, my lord, I pray, my lord, now since the stand of the government also has come, I pray that, my lord, so far as the NOC is concerned, I'm not talking about the legislation, my lord, even I would not want to be cautious because there are many facets to it. But so far as the NOC is concerned, which is
Which is the
on the
NOC?
basis of it, at page 38, my lord, annexure A.
38. Yes. Read, please, madam.
My lord, this is issued by the deputy.
And why do you
commissioner.
say that this is illegal?
My lord, this I say because none of the acts empowers the deputy commissioner to issue NOCs, and on the basis of this NOCs allow cattle markets. Under the Cattle Act, which the state is also supporting, under the Cattle Act, it has to be a registered market or it has to have license.
What does the state say in its affidavit regarding the NOC?
The NOC, with that respect to NOC, they do not say anything.
Yes, Ms. Nath.
But the basic.
Power of the deputy commissioner to issue an NOC.
The basic challenge in this petition is as regard the validity of the. some
That
provision
we'll
of the
examine.
Act.
What- And so also the NOC.
But we have said that the notification at page 39. This is issued in as per the provisions of this act 39. And this 39, my lord, this has, my lord, authorized the designated competent authority under section of the Act 7, section 8, section 10.
Yes.
This is as per the department, my lord.
Section 8, let's read section 10 then.
Lordship.
Where is section 10, madam? Have you annexed the act?
No, act has not been annexed.
Let's see the act. Cattle some cattle preservation act.
Lordship.
Even in a panchayat area.
I'm in a panchayat area.
It's not.
But so we are not, basically, we are not regulating the markets. We are regulating by this act, the object of the act is to the preserve and regulate the cattle. Wherever it is, then section 7, section 8 and section 10, these are the designated
Let's
competent
see,
authority
let's
as per
see.
provisions of the act.
What do the
My lord.
section 10?
Section 10. May I place it, my lord? Every animal market regulation, every animal market committee of recognized animal markets. It says recognized, my lord, that's a key word. Shall issue proof of sale and purchase of animals in the prescribed format to the purchaser and maintain proper record for
Where does
inspection.
it give power to the deputy commissioner to issue NOC?
But section under page 39, that notification has been issued by the government in the.
Maybe, but basically the parent section remains the same.
Yes.
Under
That has not been amended.
Under section 21, under
Section 21, let
it
us
is
see.
issued,
21.
Lordship.
Delegation of
The state
functions.
government were
Yes,
made by
delegation
notification.
for what?
Yeah.
Where does the act itself talk of NOC to run a market? Read that.
The animal market regulation. Under that section 10, every animal market committee of recognized animal market shall issue proof of sale and purchase of animals in the prescribed format to the purchaser and maintain proper record for inspection by the competent authority. And next is, if any animal market fails to comply with the provisions of this section and rules prescribed in this regard, there is a rule also,
License/registration.
Lordship.
No NOC is.
To maintain the objects ought to be
You
achieved by
can't
this.
read in powers which have not been given by the act, Mr. Nag.
What I would like to submit,
Yes.
the affidavit, we could file it today, possibly it is not on record, since the
Whose affidavit? Your affidavit is very much there.
we have filed it today,
Today,
yes, I could file it today. That affidavit possible.
the affidavit is all right by the private
By the
respondent.
private respondent.
Madam has not filed the reply.
Doesn't matter. State's affidavit was awaited. All right, get your affidavit on.
Lordship.
Affidavit file. Affidavit in opposition has been filed on behalf of the state authorities.
1 and 2.
The respondents must 1 and 2.
Lord.
The same be brought on record. Re-notify on 5th October. Let's see. Mark the attendance of Mr. Andy for respondent 3. Yes.
May I just make a humble submission that let it be recorded that day the interim prayer will be considered.
It need not be
I-
recorded,
I-
madam. Your prayer is pending
My lord, it is. It is.
for consideration of the prayer for interim relief
I'm grateful, my lord.
made by the petitioner here.
I'm grateful.
The petitioner's counsel may file affidavit in reply if so desired in the intervening period.
I'm grateful.
Item number 22.
Yes, please.
Respondent 3 has been filed by.
Yes, you have filed the affidavit on 22nd August. Yes. What is the matter about, sir?
This is the election of cooperative lordship. As per order of the Cooperative High Court, the election has been contracted and ballot has been kept in concealed lordship in the custody of respondent number 3 lordship. I am not declared as chairman lordship.
Okay. So argue that.
The Honorable High Court issued notice and respondent already filed the
They have filed it. Now, what do you want to say? Argue.
lordship.
Are you prepared or not?
Lordship, now I will chairman lordship in paragraph number.
Are you prepared to argue the matter, gentlemen? Are you ready with the matter?
Lordship. Tomorrow lordship.
Not tomorrow. Counsel for the petitioner prays for time to prepare and argue the matter. List on 11th October.
Lordship, 11th, I'll be out of town, your lordship.
When do you want then?
Any date after 11th, your lordship.
All right, then let it be on 12th 16th October, 17th, 16th October. 16th October.
Item 23.
May please, Lordship.
Yes, please.
Lordship, before starting my read appeal, Lordship, one point I have mentioned, Lordship, whatever my contentions, that is admitted by the respondent, their affidavit has been filed, Lordship. Here, my Lordship, my case is that, Lordship, I am not a landowner. I have awarded as a Zirat compensation, Lordship. And Lordship, present Lordship in appeal, read appeal, Lordship, respondent has filed their affidavit, Lordship. In their affidavit, it is admitted that I am awarded that Zirat compensation, but that compensation has not been released as because, Lordship, earlier where another writ petitions stay order is granted by the Honorable Court, several writ petitions there, and in present writ petitioner's, Lordship, his payment has not been released as because, Lordship, this case has been pending.
The other two writ petitions are pending. That is why.
No, Lordship. Now presently it's all the disposed.
All disposed of.
All disposed.
Then,
Lordship, now my question, I am
who is there for the respondents, please? MS Bora was appearing last date.
Yes, madam. She was appearing today.
Lordship, their affidavit pending, Lordship.
Let there be someone on.
Yes, my lordship may take up the
MS Bora, when counsel representing the state is not available today. Re-notify on 10th October.
Highly obliged, Lordship.
Supplementary list, item 71.
Yes, my learned friend starts. There were two documents which your lordship will remember. Two documents your lordship said to place it yesterday. Two documents, this was APS. Whether I should place it or whether my learned.
What were the two
Two
documents?
documents your lordship will recollect on APS. These are case of Assam Police Service. 28th of January 2018, your lordship remember that only to cover up that notification issued, and they have not produced that.
No, he has argued beyond that.
Now,
Mr.
my lord,
Das.
that interregnum period from 15/9/2017 till 21/2017, what will be the status? What will be?
What the argument now is coming is, forget about any notification.
That's why I'm
It's a
saying.
deemed continuance of probation.
No,
That is what the argument is.
there is a document, two document to that which is not a deemed provision period, my lord. Two documents.
So then you will have to file them on affidavit, Mr.
Yes, I
Das.
will. That's why we will file
In the
it.
midst of the hearing,
No, just my lord.
that
these
is
are-
possible.
My lord, these are so important document, my lord. No, I know, I'm extremely,
Understand?
I am embracing, I'm.
At
very-
what stage?
Refer to this at the end, because
I
his
think
other very important document is what I have to deal with today, Lordship, that night
No,
meeting.
No, if leave is granted, we'll file now itself, my lord.
What are those? Provide a copy first to Mr.
Yes.
What is the, if the Lordship, the argument is, and I'm grateful to Lordship for pointing it. If the argument is that during the period of 2 years plus 2 years, when each one of them was a probationer or temporary employee, any order of increment, any order of whether it is extended probation or not is not required, because their status will remain as deemed probationers.
That's what the argument
My
is.
lord,
We are not making any comment
No,
on your arguments, but that is the stand of the respondent.
Well, I know, this, there is reply. That's why I'm saying these three documents is important. My lord, one provisionary candidate, whether, my lord, there can be a inquiry officer. They offer a confirm employee, an inquiry officer was appointed.
Which
But
case?
this by APS
Let's see the
officer,
document.
that's why I will show it, my lord. How can it be, my lord? A confirmed, I'll show three documents before lordship, which.
Lordship, I'm
If
taking an
lordship
objection on
allows,
this.
if
In the middle of the
Problem
hearing,
is, in the
I am
midst
taking an
of
objection
hearing,
on this, Lordship.
these documents being brought on record.
Not at all, Lordship. On this, I'm taking a
That's
firm
why I know,
objection
my lord.
because this cannot be done.
That's
You
why I
can't
know.
keep improving the case when I've closed my arguments and I'm on the last leg.
Close your argument. You are-
Continuing, we are in the midst of the
No,
arguments
I
of the
know, my
respondent.
This
Mr.
one I
Just,
will
my
object to,
lord,
Lordship.
I just want to place it. If it is up to your lordship,
Your
Das, that
lordship
will be-
does not allow,
that
my
will
lord,
be
it's
too
fine.
much, Mr. Das.
My lord,
Opening
I-
a Pandora's box
No,
now.
it's okay, fine, my lord. Your lordship is
You
not
just
allowed.
informally give copies.
Yes.
If you can respond well and good.
Yes.
Informally give the
I'll
copies.
do it.
Deeply.
But we are not allowing pleadings
Yes.
now, Mr. Das. Yes.
Item 71.
I'm so sorry. I seem to have jumped the gun. I think 3 matters are still there.
3 matters are left. I didn't know. Even we didn't know. Okay.
May it please your lordship. Lordship, this is a leave application, my lord.
In this, probably Mr. PJ Saiki appeared in the SB.
Yes, my lord.
List before another bench. SB, Mr. PJ Saiki.
My lord.
List before another bench.
Oh.
Ladyship will not
Oh,
be
my lord.
able to hear the matter.
Deeply obliged.
I was looking.
Item 72.
My lord, could a date be given, my lord? Could be tomorrow,
On-
day after,
When do you want?
tomorrow, day after.
Day after tomorrow.
Deeply obliged.
Surface I matter.
Gotcha.
Yesterday's judgment you have seen. Honorable the CJI's judgment.
No, I have not seen your lordship, but in this case, I have challenged the order by the district magistrate.
Yeah.
That is not correct on the basis of wrong statement filed by the authorized officer.
That is what the judgment is. Read the judgment. Nirud, I had asked him to give a printout. I had asked him to give a printout. Just have a look at that judgment, please.
Yes.
Yesterday's order.
Look.
Passing it over. We are passing it over.
Item number 73.
My lord, this matter came up yesterday also, my lord, where the marks of the written test were totally ignored to
Hmm.
favor the daughter of the joint director of the department.
Yes, what do you say? This is total sham.
My lord, there is not.
There was no indication there in the advertisement that the selection will be made only by Viva Vasek.
My lord, kindly come to page 42, Annexure A, my lord.
Yes.
This is the minutes of the.
Minutes, you can do anything in your own closed chambers.
No, my lord, it is.
Were you under the liberty to decide this?
My lord, here it is prior to the selection, my lord.
Yes. Did you advertise it? Did you notify it that we will be doing it this manner only?
It was not.
You keep these things under covers. We'll quash everything.
And,
Where is this selected candidate?
and secondly, my lord, if your lordship quashes, my lord, one selected candidate, he has not been made a party, my lord, to the proceeding. That is, your lordship kindly come to the paragraph 13 and 14 of the impugned judgment, my lord.
Oh,
Paragraph 14, my lord. As noted above, page 69, my lord. As noted above, despite the leave granted by this court, the writ petitioner has
yeah,
failed
what
to
do you say to this?
impede the other candidate because he is also.
Vidyut Sharma.
Yes, my lord.
Yes.
Selected candidate,
My lord will kindly come to page number 10, the comparative marks is there. Now, my lord, Vidyut Sharma otherwise is also, otherwise, because there were 2 seats. There were 2 posts, my lord. Vidyut Sharma is scoring far more marks than the private respondent who was.
Doesn't matter if we quash the recruitment
Yes.
on the ground that Viva Vasek alone could not have been the criterion, then his job also goes.
Yes, my lord.
He's not made up. You are given a liberty. Why don't you impede? That kind of recklessness, then you have to face the music. You'll have to lose on this ground only.
Now, my lord, because my lord, what I was.
You had not challenged 2 things, Mr. Counsel.
Yes.
You had not challenged that notification or the communication whereby they decided that they will be doing the selection by Viva Vasek. You did not challenge it. That is the finding of the single judge. Supposing we ignore that for the moment,
Yes.
and we take into account that yes, this challenge could have been permitted even suo motu by the court. But what about this part, selection?
My lord, I am
He is a
against.
selected candidate.
My lord, I am against the selection of the private respondent because the private respondent name even did not figure out in the initial merit list. She came by virtue of a second merit list.
No, my lord.
I will demonstrate, my lord, from the annexures which are placed on record.
Show all right, show
My
the.
lord,
Now-
regarding that, may I submit?
You are
Because-
representing the private respondent.
No, I am.
Then why are you so vociferous
No,
for
no,
defending her act?
no,
her
no,
case?
my lord, because this is.
Let
the-
him argue then, all right, take your seat.
Yes, my lord.
Yes,
Now, my lord, the initial merit list is at page number 33, my lord will say,
yes. 33,
page number 33.
yes.
Now, at page number 33, my lord, the private respondent's name does not figure out anywhere, my lord. These are
This was prepared on what basis?
this was prepared on the basis of the written test,
Written test.
written test.
So in the initial shortlisting, you can say.
Yes, my lord.
The respondent was not there.
Then the respondent number 7 was not there.
Okay, then what happened?
Then, my lord, thereafter, my lord, then they have issued admit card for the viva voce.
Mm,
And then suddenly, my lord, at page number 35, my lord will see,
mm. Yes,
this is the order which we are assailing in the, which we have assailed in the writ petition,
35.
page number 35, my lord.
Mm.
Alpana Borua, her name appears in the final select list, my lord.
Select list.
Final select list, my lord. Now, my lord, we are aggrieved because of her appointment, because Bidut Sharma's name figured out in the first
First
list,
list
second list. So even if, my lord,
Where is your pleading regarding the first list? Let us see.
Uh,
How do they explain this? Let's see.
yes, my
How
lord,
do they explain this discrepancy?
my lord,
Apparent discrepancy.
my lord.
Let's
Now,
see.
they have explained it, they have said that it was a oversightness because initially against one post, we shortlisted 3 candidates.
Read the pleadings first.
Pleadings, my lord. I'll come to my writ petition, my lord.
Yes.
My writ petition,
My lord, that reading is at page 40, my lord. Our
Just
affidavit.
hold on, gentlemen.
Yes, my
You'll
lord.
get your turn. Why are you so anxious?
No, my lord, I am just.
Have you accepted the brief of the private respondent? Then what is the problem with you? He will not hear you.
Yes.
Do you apprehend?
No, my lord.
Then we'll record this then in the order. That you are so anxious to plead the cause of the private respondent. There's something fishy. Yes.
now, my lord, page number 20, para number 7, my lord will see.
Yes.
That situated thus, the petitioner was under a bona fide expectation that he would be appointed for the said post by dint of his sheer merit. However, the petitioner was shocked and surprised not to find his name in the recommendation of the on the selection board published by order dated such and such issued by the Director of Health Service, Assam. What further shocked the petitioner was that the name of one Srimati Alpana Borua, respondent number 7, whose name even did not appear in the merit list published after the written examination, has got the favor of the selection board by recommending her for the appointment of the said post.
What is the reply of the state?
The reply of the state, my lord. Affidavit in opposition, page 39.
Is it there?
Yes,
We don't think so.
page 39. They are saying, my lord, basically,
Page?
page 39 is their affidavit, my lord.
Just a moment, just a moment. Sort of. 2-page affidavit or what? Yes.
Yeah. So, my lord, in this affidavit, my lord, I would like.
What do they say about
Yes.
non-figuring of the name
Yes,
of Alpana Borua in this merit list? Your para 7.
para 7, my lord.
Hmm.
They say initially they thought that it was against one post, they selected 3 candidates, but subsequently they have corrected it that against one post, they selected.
Where is the modified merit list? Yes, all right. You can take your seat. Where is the modified merit list?
My lord, at page 44, my lord.
Yes, let's see. Was it published?
Yes, my lord.
Where was it published? Let's see.
Page
What is the date?
page 44.
Where is the decision to modify? All right, let's see.
My lord, as per the minutes, my lord, that I have referred at page, page 42,
Hmm.
because there it has been stipulated that, my lord,
Merit list prepared on basis of what? Where is the evaluation?
merit list on the basis of the written test, my lord.
Where is the evaluation? Where are the marks?
No, my lord, the house decided to hold a meeting test for.
Where are the marks, gentlemen, of the candidates in the written test?
That mark is there,
Let's see.
in their pleadings, my lord, that mark is there, my lord, at page 10, my lord.
Page 10.
Page
Let's see.
10, my lord.
To keep the original marks then ready. Keep the original record. We'll see
Yes, my
whether how many marks she secured.
And regarding the name of the figuring of the private respondent, second time, my lord, because in the minutes, my lord, it was decided that the candidates will be selected on the basis of 1:4, but initially.
1:4 is never a norm in any of the selections.
No.
It's always 1:3.
But in the minutes, my lord, that
Yes.
I have referred. at
Which government notification?
Page 42, my lord.
Yes, let's see.
Page 42, my lord. The
These are the minutes of the, you refer to some government notification.
Yes,
Where is that notification? Which says that the ratio should be 1:4. Tell us,
in the minutes, it has been.
which is the notification, sir? Apparent case of nepotism. You have to bring in that girl. That is why you made the ratio 1:4.
No,
Show us the notification and your original record.
my lord, this minor charge resolution at the office of the Director of Health Service. my
We are
lord.
not bothered which is the notification you are referring to.
Yes.
All right, learn counsel for the state. Mr. Your good name, please.
DP Bora.
DP Bora shall keep available the notification on the basis whereof government notification on the basis of which, the revised merit list was issued on 19 June 2015. Wherein, the candidates for Viva Voce have been invited in the ratio 1:4. He shall also keep the original record of selection available for the courts list on 12th October, 11th October.
Apply.
Hearing कॉल कर लीजिए वापस matter. No pass.
Passed over matter 72.
Come back tomorrow. We are providing you the judgment. Tomorrow, list tomorrow.
Supplementary list, item number 24 to 70, for third matter.
Lordship, leadership. I've also just am informing Lordship, I've got the IO and I've got the public prosecutor here for anything specific that we may require from Lordship during the day. I just thought I'll inform Lordship before I have you. If Lordship wants him in the court, we can also call him.
We don't need. You are,
Lordship,
you are more than enough for handling.
I'm the Lordship, I must say before I start, yesterday's judgment, Lordship has just cited the ratio. We were just discussing, we all need to pick a cue from that.
Which one?
Chief's judgment has come yesterday and you were quoting that in a matter today. So I said, that's a cue.
That's IT, Mr. Kohli.
I know,
It
but
just-
Lordship, somebody has to read it also, Lordship.
It props up on your phone.
I mean, I was also saying I have to go back and speak to my team at pace. Lordship,
Yes.
give me a few minutes. I'm going to answer everything that Lordship has asked.
We have given you hours. You're talking of minutes.
I'm
They're only 11:15 now.
deeply obliged.
The entire day is before you.
The Lordship, with regard to the specific query, because Lordship had raised this with regard to those 9 pages. That's the core. And I wish to dispel that notion which is being sought to be created, that A, we are trying to run away from anything. We have the facts, we've gone through it. We will satisfy Lordship, judicial conscience.
Yes.
Second, Lordship, that there is any kind of bias by the IO or in the investigation. 3, Lordship, that we have suppressed or deliberately taken the investigation in a direction that it shouldn't have been done so. 4, Lordship, which I yesterday touched upon, that we have been discriminatory with regard to A set of people compared to B set of people. Now, this A set of people, and I've said that yesterday, just for repeating, Lordship, these discharged probationers or temporary employees were those identified beneficiaries who participated in rewriting their exams on separate answer sheets, with the chairman, Mr. Paul, taking out the original, replacing this into the strong. All of these people, action was taken up. Now, as investigation is revealing, and then of course, I'll touch the commission report very briefly because it's yet to be finally acted upon, is that there are other categories that are under investigation. But this lot, this category, everyone has been treated equally and discharged. So, Lordship, 2 minutes just with regard to the state's objective. We are, Lordship, as the state, fighting 3 very, very concerted battles through our police and through our legal system. A war against corruption, a war against drugs, and a war against terror. They are also intertwined at some places, Lordship. I yesterday, on this aspect, took instructions and got the data also from the DG of the police, that Lordship, on corruption against public servants, specifically, Lordship, total since 2021, there is a renewed focus, almost regular, And we have from 2021 laid 121 traps in which 148 persons were arrested, and the public servants who are arrested are 136, with leading to cash recovery of all over 5 crore rupees. And Lordship, with regard to these trap cases, compared to the national average, our police, because I wish to just Lordship place on record that we have faith on our police service and they are doing a lot of hard work, Lordship, in this area.
We will talk about it on a different forum.
Yes.
You need not really go around patting the back of the police officers.
Lordship, where
We
they have
will
worked
talk
hard.
about it in a different forum.
Lordship, there will be failings also, no doubt. But Lordship, I will accept where it is good. We need to pat their back because we are always at the receiving end otherwise, not judicially otherwise, even the public.
Mr.
Lordship.
Kohli, again, we are reiterating, we'll talk about it in a different forum.
I will leave it at that.
Yes.
Now, Lordship, let us go.
You can go back to your DGP and ask why I'm saying so. Yes.
Although, Lordship, I am briefly aware also of some facts. Lordship.
Yes.
So, Lordship, on a different, in this Lordship, what we did is with regard to Mr. Das, I will then refer now to two things. One is Lordship, the writ appeal 96.
96.
Yes, writ appeal 96, Lordship, which is by this gentleman, Manas Pratim Haloi.
Yes.
And Lordship, he simultaneously, before the single judge, filed the writ petition criminal 30. It was mentioned at some point, Lordship said that may be pulled up here. I will deal with both. In 30, he's challenged the investigation and he's made a frontal attack on the IO. The writ appeal, of course, is...
No, we have not called the writ petition here, we suppose. Is it listed here?
No, Lordship.
So we have not called it.
Then, Lordship, I will assist Lordship in terms of the arguments from the writ appeal.
Yes.
And Lordship may take my word that when I say anything with regard to the writ petition, it is after I personally see.
Yes, yes.
So, Lordship, this 9-page is part of a seizure on a particular date. So let us look at the two seizures first, Lordship.
Yes.
The first one, Lordship, is at page 348, Lordship. 346, Lordship. Which is annexure 20, Lordship.
Before we proceed further,
Lordship.
we presume that you have a copy of this affidavit which they filed.
Yes, Lordship.
On 20th April 20.
Yes, Lordship.
You're having it?
Yes.
Okay. Yes.
But I'm coming to the core and the substance of it, which is
Yes.
relating.
Now we are looking at
it was seized all here.
page number
346, Lordship, annexure 20.
346.
Yes, Lordship. It's a type copy.
Yes.
I will go now through the next in detail, Lordship. This is, Lordship, MR number 334 of 16. And it says, I, so and so, the additional SP, do hereby search the house and premises of the accused Rakesh Paul at Bhangagarh, Kamrup by observing all formalities, etc. During search, the following were found and seized in connection with the case. Lordship may mark that this was on the 4th of November 16 at 11:30. So this is the first seizure, Lordship, the first time. After the FIR was launched in October. Now, Lordship may look at the description of the seizures. One APSC answer sheet, roll number nil, book number 1300611 of General English, total marks 141. Roll number is found to be cut, dated 1/7/14. Lordship, this, and I say it on instructions on the investigation, is the answer sheet of Manas Pratim Haloi. The very first answer sheet that we have found in Rakesh Paul's house. The first seizure was the answer sheet of Manas Pratim Haloi, who, Lordship, is a temporary employee as a taxation superintendent of tax. Then additionally, what is found? Another answer sheet by the book number so-and-so 844, total marks 148, General English. One loss answer sheet script containing pages 1 to 30, book script nil, total marks 198, code at serial number 484-687 without signature.
Yes.
Now, this, Lordship, is of someone who's Bhaskar Datta Das. Both they have been discharged. He's ACS, Bhaskar Datta Das. The rest is not material, Lordship. We may now come to 348, Lordship. This, Lordship, is the
340
second,
yes.
second seizure, Lordship, MR 340 of 16, in which, Lordship, a number of items were seized, including this, heavily relied upon these 9 pages.
Hmm.
Now, Lordship, I'll read. I so and so do hereby search the rented house. This was the second house, as stated by Rakesh Kumar Paul, situated at Shri Mantapur, while in Bhangagarh Police Station, and seize the below mentioned items. Place of seizure is given. Date and time, Lordship, is the 12th at 2 a.m. Now, Lordship, number 1 is not material, cash of 10 lakhs in terms of what we have to answer. Now, Lordship may start noting from the second. APSC answer scripts of general study dated 27/7/2040 with a book number 1315499. Total marks 86, official code 825, serial number so and so, having signature of examiner. This Lordship is of Amrit Jyoti Sharma, who is discharged, ACS. Now, Lordship, this is the general study. Now, why this becomes important? Because we will find that there is multiple question papers answers of the same candidates. So Lordship will note on the next serial number, which is Roman 2, the marks have changed from 86 to 186. And it's the same general study papers of the same Amrit Jyoti Sharma. Lordship, everything subsequent is based on forensic assessment. I'm now having the benefit of that. Answer sheets without any book, etc. Then next 3, 1 general English script paper of APSC dated so and so, which book number 199, official code 922, marks Lordship 89. May Lordship compare with the next entry, marks 189. Now, again, it's the same paper, Lordship, and of the same candidate. In this case, it is Amrit Jyoti Sharma. Discharge, Lordship. So both are, one is general studies, one is general English. Now, Lordship, after that, number 3, 2 APSC loose answer scripts having without book number. So no identity, serial number, signature of invigilator, signature of scrutinizer, signature of first scrutinizer, and signature of second scrutinizer, packed in an envelope written as Sukanya Das. Now, one minute, Lordship, we may just look at this seizure. No details are there. A name is there about something in an envelope. The first page is missing compared to the others where I have specific information on which my investigation now can be specific. So I have a needle in a haystack, which is part of the investigation, and I'm going to do it. Now, Lordship, similar to that is point number 4. Now come to 5, Lordship. In 4, I must point out, Lordship, this Nava Pathak. He was not a candidate. He's not come across in our investigation as being a candidate. But it's seized in Rakesh Paul's house. Now let's come to 5. 1 answer, APSC answer script of general English dated 1/7/2014, having without roll number, no vide book number, roll number, wide book number 13013-534, official code number 1213, having marks 199, having signature of examiner, first scrutinizer, second scrutinizer, and vigilator. This Lordship is of Bhaskar Chandra Dev Sarma, ACS officer, again discharged. Lordship may just now read it with point number 6. 99 becomes 199, same general English, same candidate, Lordship. I'm pausing for a minute. In all these cases, Lordship, essentially, wherever there is a clear identity of a roll number or the invigilator or the scrutinizer, we have now.
Just one query. Your case is that they substituted the original mark sheets with the fake mark sheet in the strong room of the APSC.
Answer sheets.
Answer sheets.
Yes.
So how these answer scripts are found in this house?
That is the
rather than
right, Lordship.
No, but your case is they were put into the safe.
Lordship.
But the recovery memo says
Lordship, 3 things to say. In this scam, multiple things were happening with Rakesh Paul. First, he's not supposed to be opening the strong room and taking out anything. 1 minute, Lordship. Just 1 second.
Yes,
that's point number 1, Lordship.
Obviously.
Number 2, Lordship, he's not supposed to have the custody of that in his house.
No doubt about that. Yes.
Those candidates, their scripts cannot be here. Now, I am pointing out on 1 recovery, Lordship. The investigation has spanned much more. We are on the 12th, 11th supplementary charge sheet, 1 the original. 12th charge sheet. It's an ongoing investigation. It hasn't closed even today. And the case diary is progressing. I will satisfy Lordship even on that because I can't speak on it. I can only place it before Lordship. And we've carried it with us, Lordship. So my point is, It's very easy for someone as Manas Pratham Holai, and I'm going to keep building on him further, to stand up there and raise an objection in terms of trying to create doubt on a criminal trial aspect, which he should duly do there, and he has every right to do there, and try to say as if our investigation is flawed. Our investigation and action of the state thereafter is based specifically where there is irrefutable as far as we are concerned material. Where it is ongoing, it doesn't say the state won't take action, but we will take action. Otherwise, tomorrow they'll say we are treated equally, and they will bring the higher category with lower in an FIR, Lordship. And of course, Lordship has the experience of enormous criminal work. I don't, I must admit, Lordship. But if there are 40 people accused in it, approximately, just a figure, and we find material, file charge sheets, the court can say we are not happy with the investigation, Your Lordship. We may continue with investigation. We may subsequently find that 2 or 3 are not good enough. But that doesn't mean that all the 40, someone who's at a pedestal where there is enough evidence, a charge sheet is framed, the charges are framed. He turns around and said that this person, since you did not file a charge sheet, I have the right now to say I'm being treated unequally.
No, they are not arguing a criminal trial, Mr. Kohli.
I know, Lordship.
You are trying to confuse the issues. They are trying to argue, build up a case that you have treated equals as unequals in this decision of discharge.
Right.
They are
And
not,
I'm
never
here
referred to criminal
satisfy-
trials.
Yes, Lordship. I'm
They
here to
never
satisfy
refer to criminal
contrary.
trials.
To contrary, and I will come to that.
Yes,
Now, Lordship, as I pointed out, 5 and 6.
yes.
Lordship, just as a matter, I will also be dealing with the fact when they were sent to forensic, when they were received, because this aspect of alleged delay has also come out as if the IO is sleeping on it. So I will come to that shortly. Then point number 7, Lordship. One APSC answer script of general studies dated 27 July 14 without roll number, Vide book number 1316013 and official code number 1093, total marks of 104, having signature of invigilator, examiner, first scrutinizer, second scrutinizer. This Lordship is Bhaskar Dev Chaudhary. Sarma, Lordship, I beg your pardon. Bhaskar Dev Sarma, same as the last. So Lordship may note, point number 6 is English, point number 5 is English, different marks. In 5 and 6, 99, 199. The second is general studies, Lordship. And Lordship may note, I will also come to another interesting aspect on Mr. Manas Pratham Haloi. His answer sheet is found the first day, 1 paper. There are 6 subjects. 5 are not existing anywhere. We haven't found those 5. And his claim for coming back is on the basis of 1 that is found in the accused house, Rakesh Paul, the kingpin, and 5 missing. But I will come to that also, Lordship. Then Lordship number 8. 1 APSC loose sheet answer scripts of general studies dated 14, roll number so-and-so, book number so-and-so, total marks 194, Lordship. Now, Lordship may note 7 and 8. So in 7, general studies becomes from 104 to 194.
Yes.
So Lordship, there are to answer also Lordship's query. He was accentuating these things in different manners. Now let's come to 9. 9 is where the so-called issue has been raised. Total 9 pages of APSC tabulation sheet of combined main examination, having roll number, name of various candidates, general studies, general English, optional subject 1 and 2, mentioning some marks of various subjects and pinned up in a small size paper mentioning so number with 1 name, second number with another name, third name, fourth name in a media size envelope. These, Lordship, are those documents that they have filed. Now, Lordship, I have 5, 6. I'm not reading 10, 11, 12, 13, 14, Lordship. It's not required. Now, Lordship, this may note the date. Lordship, this was sent for forensic on 8/8/19 and received on 5/4/21.
Seizure was made when?
16, Lordship. I'm coming to that. That's the point. So seizure, Lordship, is on 12/11/16.
Yes.
Sent on forensic on 8/8/19.
Yes.
And received on 5/4/21. Okay, Lordship. Okay.
Yes.
Now, Lordship, in the other people before this 9 pages, each one was arrested, evidence was there, things have happened, but I'm now on the 9. So, Lordship, the next question that will come up, which is logical, that why it was sent in August 19 and not when it was seized in November 16.
More particularly, when the IO has prepared a tabulation, which is there at page 340. wherein the fact of marks being increased of these 42 odd candidates is mentioned.
So Lordship,
Hmm.
I will seek Lordship's indulgence to make all the points because they will get answered in there. Because I have multiple things to say on this sheet also.
Yes.
This sheet is not sacrosanct, Lordship, because, and I must point out at the threshold, and I have that details later, but I'll make the argument now, that Lordship, in every matter that you would see proceeding in this seizure, there are 3 or 4 things that are importantly there. The scrutinizer, the second scrutinizer, examiner, roll number, some detail is there. This Lordship, in all probability, and I will say because we've got the official document from APSC, submitted it in the court, 13 and 14, which has the examiner's signature, which has this. Those are the documents. If there is any tampering, it becomes important because that's the final document. This appears to be some rough sheet. No details are there with regard to roll number, with regard to candidates. So my investigation is more specific on where I have specific details. The others are ongoing. And this is not sacrosanct. This particular document, this is not the basis of the investigations against those who have been discharged in the other case. But I'll build on that further, Lordship. Each one of them, Lordship, was arrested. The minute the forensic started getting received, Lordship, we started filing those charge sheets. For example, Lordship, take the first page just as an idea. This is an ongoing process. In item number 2, Lordship, it was sent for forensic on 28/12/16 and received on 11/1/17. It's not as if we have sat on the forensic. On each case, wherever we had a lead, immediately we started sending immediately. We received it on, when we received it on 29/3, he was arrested on 3/5. So there was a pattern. When we got a lead, which was there, which had some detail on which we could act, actionable input, we sent it for forensic, got back the feedback, and went for the arrest thereafter. And of course, eventually charge sheets have been filed. This is a 9-page tabulation. It is not also, Lordship, respectfully, sort of matching with the actual tabulation in the APSC, which we've seen subsequently in 19.
This tabulation is by the FSL, not by the IU. There's a tabulation of the FSL, Mr.
Yes, Lordship, of course.
So this gives a conclusion that this is the change in marks of those particular candidates. Their argument is, you had the material in 16, why did you send it in 19?
I'm coming, I'll deal with that, Lordship. It's just some more arguments.
So this, what you are arguing, that this tabulation is not sacrosanct, that may affect your own trial. If you are disowning this document, that's up to you.
Lordship, I'm.
This is a FSL document, Mr.
Lordship, I've understood where it's coming and I'm obliged for that.
Yes.
My argument, Lordship, is that eventually we have to see what happened within the APSC. That is the highest threshold, Lordship. If there is a change, something answer sheet, for example, in this particular document, if it is found in Rakesh Paul's, eventually with leads, we are able to say something, send it to the FSL. We get back a feedback. It will confirm who are the people who are in it, or etc. But it's not going to be compared to, say, the answer sheet in which somebody's signature, everything is there. Now, Lordship, when I have in this seizure of 17 items, 15, 16 items, something in which I'm finding 2 answer sheets with marks change, with roll number, I'm immediately putting it into action. It's not that I'm picking and choosing. I have to also have something to ask clarity about what I'm asking before I send it, Lordship. How do I compare, say, item number 7, 8 with 9? There is something specific there.
Yes.
And Lordship, we've done it. That's the next point. It's not as if we are not doing it.
Okay.
Lordship, now. So, Lordship, during this period, which I was trying to relate to November 16 up to August 19. This is that period, which is the so-called period of, if I may call it delay, though I don't consider, I just wish to point, Lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 charge sheets were filed, Lordship. 10 charge sheets were filed beginning 24th of January 2017.
Yes.
And the last one, Lordship, I mean, 10 in this period are, Lordship, up to 26/8/19. From 17 to 19, 10 are filed, Lordship. The latest one has been filed on 20/12/21. So basically, I'm making an argument, Lordship, that the investigation is ongoing, the IO is working on it, and he's taking action in the case. And that matter which they are challenging is not a closed matter, or it's a matter that has been discarded. But wherever he's finding sufficient material to go on, he's moving also in that direction. Now, Lordship. Now, Lordship, if I may, I'll come to the case diary little later, Lordship. And I'm making that. Our case diary will show the progress of it, which I'll place before Lordship just shortly. Now, Lordship, the second point, and it's related to this, is that all of this material of the investigation, which has led to the charge sheets, those who are dismissed, and which is part of the continuing investigation up to the last charge sheet and perhaps whatever's in the future, that, Lordship, was duly considered in that Commission of Inquiry report of Justice P.K. Sarma, which came through the PI. That Commission of Inquiry report, Lordship, I have just three things to point out for Lordship, so that my story is complete, Lordship. That there was no separate investigation that was considered. There is no comment in terms of the investigation. There are findings qua the investigation. In that also, wherever, Lordship, our cases where there was very strong, what we consider extremely or irrefutable evidence, Lordship, of such as rewriting, replacing the answer sheets, a duplicate answer sheets, two answer sheets, like I pointed out in this MR40, Lordship, those were the cases that were discharged. And there's no fault with that. There's no discrimination there, Lordship. With regard to the other aspects, Lordship, he has made in his report certain recommendations.
Yes.
In one of that recommendations, Lordship, is a point related to whether we should consider scrapping the whole examination. And, Lordship, that is a point which the government in its wisdom feels that there are also innocent people who are not involved in the scam. And when we have made an effort to segregate the tainted from the non-tainted, that perhaps may be an overreach in terms of the outcome. But what I need to point out is, in the meantime, this was all found for 2013 exam, Lordship, which was the 2015 batch. The 2014 batch report is pending, and that, as per my instructions till last night, he has asked for time for about a month or so, 4 or 5 weeks, where he'll submit. The government has decided broadly to take a consolidated view with regard to the rest when we have the 13 and 14, rather than look at it piecemeal. So that is also just to point to Lordship, what is the status? And it's not as if we are trying to delay. We have a reason that we would like to proceed in this manner, Lordship. Now, Lordship, may I just respectfully, for a moment, share with Lordship. Now, Lordship, may just note another important thing, which is when, after which we send these 9 pages, is that the mark sheet and the scrutiny slips were recovered or taken from APSC on 28 August 19 and 12th September 19, which is the record of the APSC. And these were sent for forensic, as also these 9 sheets in August 2019. So we, in our investigation, took out the actual material, made a comparison, and have sent it further. And Lordship, that also helps.
Any particular reason for this benevolence?
No, Lordship, there's no benevolence. That I can see. Absolutely. And I say it absolutely, Lordship. Clearly, no benevolence.
Let's see. Okay.
So, Lordship, may I show Lordship the case diary for a minute, Lordship?
Yes, yes, as per your convenience, as you want to proceed.
We have, Lordship, we have one copy. The originals are all in the trial court, Lordship. And Lordship, we have flagged it. I am not at liberty to read anything. I just request. I have not marked it also, Lordship. It's not correct to give a mark copy. So, Lordship, the first flag deals with this note sheet related issue, and then what is happening further is the next 2 flags. I'll wait for a few minutes.
Yes. You're referring to what?
Lordship, there are 3 flags. Sorry, Lordship, 2 flags.
Two.
So,
Yes.
Lordship, may just open the first flag. That deals with the note sheet aspect. Yeah.
Ms. Kohli, if we briefly scan through this case diary noting, what comes out is that the answer sheets were already in possession of the IO. They were filed along with the charge sheet. Then from the court, he prepares the summary. That is why we just refer to the word benevolence.
Has Lordship read the second part also, the second flag, Lordship?
Yes.
There are two flags.
Hmm.
Which is about the continuation of the investigation, Lordship?
Yes.
Flag mark. I don't have the paper.
It doesn't refer to what this tabulation says. Yes. If the tabulation, what your unimpeachable evidence is to be considered, that is the tabulation prepared by the FSL after analysis of all the answer sheets. And in that tabulation, there is a clear conclusion that as many as what he was referring to is about 40 candidates are there whose marks have been increased in the same manner.
Lordship, in this very tabulation, there are, subject to, of course, correction, but it's an instruction, but I think 24 people who are part of the discharged, against whom these answer sheets and all that. So I'm making a stand consistently, Lordship.
That's what the question is.
Right, Lordship. And I'm making
why you leave out those other
Lordship. It's not about leaving it, Lordship. No, Lordship. And second is, with respectfully, Lordship, this is not an attempt to leave out.
Mr. Kohli, 4 years down the line, you have the report in 19. What have you done till now?
1 minute. And Lordship, respectfully,
Yes.
I must say that.
Yes.
And it's, the time cannot be that factor, Lordship.
Time has to be the factor.
No,
They are
Lordship,
discharging public functions.
Yes, Lordship, respectfully.
Yes.
And I say that with a sense of responsibility.
Yes.
With no ulterior motive in what I'm saying. It took my family, Lordship, 40 years to get a judgment finally in my favor. 4 generations, 3 dead people. Lordship, time can't be the factor. It is justice at the end of it.
In this scam, if you say that time is not the factor and the people who are tainted are allowed to function on the posts for reasons we need not comment on, but the fact is apparent on the face of the record.
Lordship, on this, I would respectfully say,
Yes.
of course, Lordship, I of course bow to what Lordship says from the and flows from the bench. But my respectful submission, Lordship, is that actually action has been taken where it is. The investigation is on. In that period, charge sheets are being filed. Nothing has been closed. There is a commission of inquiry report, which is also having a set of
If you're
findings.
relying upon the commission of inquiry report, scrap the entire thing.
No, Lordship, not
Then-
no. I am pointing out in the totality of things, many things are happening, Lordship.
Anyhow, you have a right to project the things in your own manner.
Yes, Lordship. I
Very
am
well.
right. And
Very well.
Lordship, my argument.
You say that everything is just clear like milk. The justice has been done by the URIO. That's what your case is. Okay, take a note of.
Lordship,
Very well.
on
Because we are frankly telling you, you are not able to explain this.
Lordship,
This apparent segregation of tainted from the tainted. Apparent.
Lordship, I will continue to stand on the same footing.
Yes,
Lordship,
of course. You have
which
your
is mine.
instructions.
Because I know there is a second part to it. also. Because Lordship, respectfully, my argument is, which I said yesterday and I'm repeating. I need to know, show me one case that they say that there is an identical case that I have not acted against. I have acted against a set that I place in the highest category and immediately take action. The
Yes.
rest, as investigation is revealing, I have reserved my right and I have my right to take what action I have to take.
Yes.
Because Lordship, that is there. But what their case is basically, free me or demolish the case on the basis of something that can't be compared.
Yes.
That is the crux of what I'm arguing, Lordship. Let me build further, Lordship.
Yes, yes, carry on, please.
Lordship may come to the actual appeal.
Come to.
This appeal itself, Lordship.
Hmm.
From page 40,
Yes.
31, Lordship, para 40.
31. Yes.
Lordship, I have yesterday spoken about trying to distinguish needed jurisdiction from a criminal rights that they have in a criminal trial. I have spoken about them seeking a mandamus and what would be the requirements of satisfying that requirement of seeking a mandamus. I've argued about suppression, I've argued about clean hands, etc. I have something to say on the appeal. Lordship, from para 40 right up to Lordship, para Lordship, it's several pages, so Lordship will give me a minute. 69, 68, and a little bit up to 72. Lordship, it's a complete word by word copy and paste of writ petition 30 filed before the learned single judge, challenging the investigation and challenging the IO. Filed in 2021, copied word by word. And sorry, Lordship, so clumsily that they have not been able to replace the word petitioner with appellant also. The one thing that they've changed is investigating officer, R2 is written there because he's R2 to R1 here.
Yes.
Their crux of their argument, and Lordship, I would say, I'm not reading para by para, but it is from para 40, including the tables, charts, everything, right up to para 72 minus one para in between, which is para 69.
All right.
Word by word copy of the writ petition 30 of 21, criminal writ petition 30 of 21, filed before the learned single judge. And it will be seen also everywhere the word is the petitioner, petitioner. Word by word. I've gone through it till early morning, read it para by para with my colleague. Lordship, respectfully, Lordship, stay in this appeal then. Who's Manas Pratim Halwi? The first answer sheet we get in the first. Taxation superintendent who's temporary. His own cases, I have been there for 3 years, some odd months, less than 4 years. In his particular case, one answer sheet is found in the house of Rakesh Paul. And nothing else is available. Where are the 5 papers? Let us also, Lordship, I'll finish this and point out his stand in the trial court. The stand of his right. Lordship, what about what is impugned in the proceedings is the discharge order, not the investigation. In that writ petition 30, they are impugning the investigation. So, Lordship, as one point float from there about confusing, I am also making a further comment on that, Lordship. It's my submission. It's a deliberate attempt to somehow
Their
confuse.
argument, foundation of the argument, Mr. Kohli, is
Lordship.
that a discharge is based purely on the basis of a police report, which is tainted. That is the argument. So that obviously is a comment on the investigation.
Lordship. And the second part,
Yes.
to it is there are 2 arguments.
Second part is, of course, probationer.
And I have a right under the rules. I have exercised it.
That's,
There are 2.
so presently, you are addressing the court on the first part.
Yes, Lordship.
Yes.
So my other argument remains consistent. Tainted entry. They are temporary probationers. Within the period of their probation, they are deemed to continue on probation till the maximum period. No order of satisfaction. That doesn't change their status no matter what they are. They have a problem with the investigation. They have a problem with the IO. The court wants us to get a new investigation. The court wants us to have an STF, whatever, Lordship. That is related to the investigation. But it doesn't change their status or position, Lordship, qua the fact that they are temporary and we have, under the rules, discharged them for their tainted entry. Second, Lordship, that is the threshold, Lordship, their entry itself being tainted. Second, Lordship, it was, respectfully, Lordship, their duty when they write this and raise this argument to have informed Lordship's courts specifically that this was the pleadings that are majority part of the pleadings in the appeal are a copy and paste from the writ petition which is pending before another bench. Lordship, respectfully, this is not just suppression. This is not approaching with clean hands. Trying to attempt to achieve the same objective in 2 separate petitions before 2 separate courts in the same High Court, Lordship.
Yes.
It's a comment on conduct, Lordship. Lordship, there was another aspect that had come up. One is the argument of Article 14, I'll place one judgment, although Lordship, that's settled law, that it can't be applied in the negative. But since I'm carrying a judgment, I'll share that with Lordship. And then Lordship, there was the argument on the 3 approvers. I can address those arguments with Lordship.
As per your convenience. As per your convenience.
I'm only here to satisfy because the question came, Lordship.
Yes. It was an argument. We have not put a question. That was an argument coming from their side.
Lordship, just before that, one stand on Manas Pratham Haloi. 1 second before we get that. We have a copy of the framing of charges order. Here a copy. I'd like to just see the stand of this gentleman before the learned trial court, which is recorded in the order of framing of charges on 19th of April 2022. Lordship, my colleague is just taking it out from the bundle. Yeah, we got to give it.
What do you want to refer from?
I just show Lordship. In this, I'm just talking about the conflict stand and his admission, Lordship, which is recorded in the framing of charges at page 10, Lordship.
Mr. Kohli, do we need to tell you that proceedings of a criminal trial can never influence the outcome of any other proceeding for that matter?
I'm on the point of conduct. And I must point out the different charges because he's trying to raise serious questions against us. And I'm in my rights, Lordship, to just point out what is his stand.
File this on record then.
This one certified copy. 3 lines are there only.
It is not a certified copy. Give us a certified copy. We'll read it.
We'll give it, Lordship.
Yes. Okay.
Take out the 3 judgments.
Yes.
I didn't want to say, my lord is giving in a midst of hearing my learned friend inside. I am not saying anything, my lord.
We have returned it back, Mr. Das.
Yes, no, absolutely no problem.
Yes. So that is a public record, part of the proceedings of the criminal court. But still, it's not a certified copy. So we are not considering that. Yes.
Given the judgments, which one should start? Yes, Lordship, I can only say that they had made an argument that this was printed in the private press. It was printed in the government press. We have those requisition records also.
We don't know. Mr. Kohli, there are certain pleadings in this appeal which probably were not there before the Red Court. They have not been controverted, we'll tell you, on the face of it. Those pleadings remain uncontroverted. You are aware of that?
Yes, Lordship.
Very well. Okay. We also told you that this is a fact because the appeal has been entertained and the pleadings are there uncontroverted. If you want a particular part of the pleadings, you can refer to paragraphs because you are referring to various paragraphs. So you can go through the paragraphs 48 onwards if you want to. And more particularly, para 55, wherein they have pleaded discrimination in this
I've seen that.
action. Yes.
Yes, Lordship, I've read that. That is the case which they pleaded in both, which is word by word as my case. They are pleading discrimination at 2 forums. Lordship, I've given a set of 4 judgments, Lordship. The one on negative equality, Lordship, is a Acha, Lordship. I'll start with the 3 on the approval, Lordship. AJ Paris versus State of Madras, Lordship. It's a 3 judge of 1954, SC 616. Lordship may come to para 9. Para 9.
Yes.
The facts proved in the case do not support the first contention. The order of the district magistrate tendering pardon to the approver was passed on 1952. Albert admitted before the district magistrate that the confessional statement made by him at Bombay, a copy of which was read over to him, was voluntarily made by him, and that he accepted it as a true statement of all that transpired in connection with the conspiracy, and also about the murder and disposal of the dead body of George. And Lordship may mark, the district magistrate thereupon passed the order that it was a fit case for tendering pardon to him under section 337, which is paramateria to today, Lordship 3078, of the CRPC. The objection that the tender of pardon was illegal in the absence of a formal order releasing Albert as an accused was passed and was never raised before the courts below. Apart from this, we are of the opinion that there is no merit in the objection. And Lordship may mark finally, we think that the moment the pardon was tendered to the accused, he must be presumed to have been discharged, whereupon he ceased to be an accused and became a witness.
Okay.
Second one, Lordship, is CBI versus Ashok Kumar Agarwal. This is Lordship 2013, 15 SCC,
Yes.
222. Para 27.
Yes.
The aforesaid view stands fortified in the judgments of this court in so and so, wherein it has been held that the order of pardon cannot be passed mechanically and the court has to apply its mind while
Why,
exercising.
why are you citing these judgments, by the way? We may ask.
Lordship,
The
this-
grant of pardon is not under question.
No, Lordship, it's not grant of pardon.
Then-
It is on the argument to show three things only, Lordship. The
Mhm.
first, that once there is a grant of pardon, they are not on the same footing as the accused, which I argued yesterday, Lordship. And with Avishka, Barua and the two, their evidence is being on as witnesses. They are not breaking. They are going well, Lordship. They are trying to basically say government should take action against them. Government is in its rights to consider its action because we treat them separate with regard to these people.
Okay.
That's the crux. So there are these three judgments, Lordship.
So a
on the same.
person gets into the service by using fraudulent means, and then he says that I'll support you in certain aspects.
Lordship,
Please save my service.
no, Lordship.
Whether
Respectfully, no, Lordship.
The fair employer is entitled to take
So,
this.
Lordship, the counter to that, respectfully, Lordship, would be that a person may commit murder, finish, be pardoned, be an accomplice in a murder, he's then considered by the court. Now you're on the reformatory process. So, Lordship, in this case,
Criminal trial, Mr. Kohli, you will never confuse the concept of a criminal trial with the service jurisprudence. That's what our view is, of course, subject to correction.
not at all, Lordship. It's not
Yes.
subject to correction. I'm merely submitting, Lordship.
Yes, very well.
And Lordship, as I said, my case is on those two arguments. The first one I've done, the second is building on whatever has come from the. I've done. I have nothing further.
Okay, okay.
Lordship has said on the season, it's not uncontroverted, but that's okay. We'll see on the pleading and bring it on record.
Yes.
This was Lordship on the. Lordship, the argument which was made was about the answer sheets, fake answer sheets, and about the fact that they were all printed in the private. Our case is that the original answer sheets of the examination were printed in the government printing press
Mhm.
for both the years. And there are proper requisition orders which have come also. They are part of it.
Can you show us from the pleadings?
No, Lordship.
Then forget about it. Yes.
We had a certified copy, but Lordship, I was only answering.
Okay.
I'm.
That's all?
That's all, Lordship.
Okay.
When the third voice, Mr. DK Mishra.
He has to be here now.
That's why I don't know. No point. No, he will not do that. Shall we reply to that? But with the lordship permission,
Yes.
my lord, there are few judgments which we are going through it, judgment. Number of judgment I have to distinguish. If it is, I know, my lord, that's, my lord, if it is not inconvenient.
This is continuing.
If it is not inconvenient, my lord, just I will place it tomorrow morning. I'll take, my lord, 1 hour before your lordship for rebuttal and I'll close my argument. I'm extremely sorry, my lord, because these judgments, I thought, my lord.
Doing this in a piecemeal manner.
Yes, I know, but it's
Really-
still going on.
Really difficult, actually.
Yes.
You must have expected, anticipated that he has concluded, virtually completed the arguments. Today it was only on your 9-paper sheet,
Yes, sir.
basically.
No, that particular 9-paper tabulation sheet, my learned friend.
Today the argument was
I
only
will-
on that.
Yes, only the judgment I will place, but to that, my lord, answer is as on date, my learned friend, I'll just rebut with my learned friend as saying. My lord, as on date also, there is no answer to the 9 tabulation sheet, which my lord, learned friend want to say. He didn't have any answer to it, my lord.
Yes,
On that part, my
try to justify the action of the investigating officer, claiming that the investigation is still continuing. So hope that the action will be taken.
No, what we said, my lord, we said
Yes.
that if all are tainted, let everyone goes. How you are distinguished? This is an investigation we have. That's what I was pointing out before your lordship. This is what your investigation is on. And today you are praising the investigating officer. Why you have done it? On the face of it, the documents features is I have
Mr.
placed
Chaudhary
before
is
your
here.
lordship.
Let's see if he responds. He is rejoinder. Let's see. Yes, Mr. Chaudhary.
Yes.
Your rejoinder.
Yes. I'll do that. One number, I think. Please take it. If the lordships would kindly have item number 63 for a particular pleading, my lord. Yes. How far did you do? Oh, sorry. Come on. Item number what? Sorry, 34, item 34. My lord, my learned friend amongst others had made a submission that if such tainted people are to be recruited, then it will, I mean, the public image will be.
Yes.
Therefore, to restore public faith, it is also required that these people are not permitted to serve the state.
Yes.
Now, my lord, if your lordships will kindly come to page 206 of this paper book. What had happened, my lord? Everything started with the arrest of this gentleman. His name is Nobo Kumar Patil. Nobo Kanto.
206.
206, my lord. Please come to paragraph 3. It was an additional affidavit which we filed before the learned single judge.
Yes.
The petitioner humbly begs to state that state respondents would like to contend that if the petitioner as well as other similarly situated candidates are to return to their offices, then same would be contrary to public interest. And it would also cause
Reinstatement of those named in the FIR doesn't make any. FIR is not an encyclopedia.
My lord, he was the person who was caught red-handed paying 10 lakhs of rupees.
Who?
This gentleman, Nobokanto Patil.
So he's still in service.
The FIR started with this.
Harshjyoti Barwa.
No, my lord.
You are referring to what?
I'm referring to this Harshjyoti Bora's writ petition appeal.
Yes. Affidavit at page number
206.
Yes.
It starts at page 205. It was an additional affidavit filed before the learned single judge.
By
the Harshjyoti Bora, one of the writ petitioner.
Yes, yes.
His case was, how come this Nobokanto Patil, who was the man who was caught red-handed with 10 lakhs of rupees?
Where is it? Where is it mentioned?
I'm coming, my lord. It is in the affair. That is how the case started. Now, this man has been reinstated by.
He was caught red-handed.
Yes. He is the only named FIR accused.
Can we see the FIR, please?
Please come to page 208 before that, my lord.
Navajyoti?
Nobokanto Patil. I think my learned friend must be having the case diary. In the case diary, it is there.
No, the FIR is here, no, with us.
Yes.
FIR, someone must have placed the FIR on record.
Yes.
Yes.
Please come to 208, my lord. In continuation of the departmental proceeding which was drawn up, while show cause notice dated placing Sri Nobokanto Patil under suspension by dated so-and-so, is hereby reinstated in service and posted in Town and County Planning Office, Dibrugarh, in his capacity. This has the approval of the Honorable Minister, Town and County. Now here, my lord, public image is not tarnished. And he was arrested from Dibrugarh. He was the first man.
He must have been charge sheeted as well.
Yes.
He's still in service.
Yes.
I will respond to that, Lord.
Yes, of course.
Yes.
We have to take your response.
So, my lord, I have just to counter to what the argument was flowing from the other side, my lord, I placed on this. Now, my lord, let us come to the main.
Is he is he a candidate of the same selection process?
No,
He's a earlier.
otherwise, he's an employee, government employee, my lord. It was he.
So already
brought
he's
up
being
that-
prosecuted now.
My lord.
He's being prosecuted. Suspension had to be revoked, Mr. Chaudhary, whether any DP is going on or not. We don't know.
Why DP has not, they will have to answer. We have been
You can't claim parity with that man.
not claiming parity, my lord. It's not a question of.
This is
claiming
not the,
parity.
this is, you see,
What I-
basically, you are on casting aspersions on the investigating officer's report.
No, I'm not on that, my lord. I have referred to this, the particular paragraph and document for the simple proposition, my lord. State on one end is saying, if people like our clients are, my lord,
No, obviously, your clients can't have any justification.
then how
Basically,
come
can't
this
show.
Navakanto Patil?
Yes.
Navakanto Patil, why have you, he should have also been dismissed from service?
We'll,
Now, why
we'll
are
ask
you
them.
doing double standard?
Yes.
Therefore, my lord, it is a
Double
pretense.
standards, you see, Mr. Chaudhary.
Yes.
In this situation, there can't be any negative equity.
Now, yes.
Plain
No,
equality.
I'm not claiming negative equality,
Yes,
my lord.
yes.
What I'm saying is, I'm just trying to portray the state's role vis-a-vis the appellants and some others.
Yes.
Now, my
You,
lord,
of course, put them a question regarding same set of people,
Yes.
in the same recruitment, the differential treatment, that we have put them a question.
yes.
They said that they are justified.
Now, my lord, coming to the merits of the case, our case is.
Your argument is, basically, you advance only one argument.
Yes.
Probation completed, deemed confirmation.
No. No, in case of Assam Police, I made that argument, my lord. In case of ACS, my argument was, you have taken note of a misconduct to get rid of us.
Which is pre-entry into the service.
Yes.
So that could not have.
Could
So
not.
that's the foundation of the action.
Yes.
That's your argument.
Yes.
Very good.
Now, my lord, another aspect which I would like to highlight, my lord. They have, as far as the ACS officer are concerned, they have invoked Rule 20C. Now, Rule 20C speaks of some information coming to the hand of the governor.
During the service period.
And based on which, my lord, they are to form an opinion whether this man can be retained or not. Now, that exercise was never undertaken. No exercise was undertaken for the purpose of finding out whether the appellants before your lordships are fit to be retained or they should be, their periods should be extended further. On the contrary, based on some allegations, my lord, their cases were decided and they were discharged from service. To that, our argument is, this is violative of Article 10 and 11 or the rules of natural justice. My lord, hang us. By all means, hang us if we are guilty, but follow the due process of law. That's the only case. Question is,
What
my
is the
lord.
exercise required in confirmation or non-confirmation of the probation?
Yes.
What exercise is required?
No, my lord, the records must reveal that maybe during the period of probation or maybe at the end of the period of probation, an exercise will be undertaken to find out whether we are suitable to be, confirmed or not.
Suitability. No?
Yes.
Suitability.
Suitable.
On suitability aspect, they say that once your involvement in that pre-recruitment scam
Yes.
became apparent,
Yes.
the state thought that you are not suitable to.
No, my lord, apparent from what?
Apparent from the records collected, that they say that the IO's report is sacrosanct. That's
Yes.
what their case is.
Now, whether my lord, are we not entitled to rebut that? Some allegations are against me based on some allegation.
I say
am
that
thought
the
to be-
material is of such nature, how your dual answer sheets were found
No,
in
my lord.
Rakesh Paul's residence.
No, my lord, maybe.
Maybe.
That
That's
that is only in the realm of allegation.
No, that's
No.
a fact
No.
which has been looked into by the learned single judge. The record is there.
No, no.
We can look at the dual answer sheet.
No, that's not
What is the
issue, my
problem?
lord. That is an allegation. When was
Chaudhary,
the
that's a
opportunity?
fact. That's a gospel truth. The fact that your mark sheet has been found before the action was taken, the report of the handwriting expert was there. Is there a denial from your side? It's not my handwriting.
Then why this criminal trial is required?
Criminal trial so that you can be punished. You can be put behind
For
bars.
taking an administrative action, there is no other requirement?
That's
Only
what
only because police during investigation has found something.
Not
and that
only
is the gospel's truth?
not something, Mr. Chaudhary.
No,
It's
no.
beyond something.
No.
Basically, the material should be
Lordships-
unimpeachable on which this decision can be
My
based.
lord, with all submission, all humility at my command, I'll submit, my lord. Lordship is examining the decision-making process.
Yes. So
Let us not
we'll
go
see
to the merits
we'll
of the
see the
decision.
record. Then all right.
Yes.
We'll see the record.
No.
What was the record presented to
What
the?
is what is the record?
Hmm.
What is that information?
Let's see.
Information is part of the police record.
We don't know. Let's see the original
No,
record.
that's the only thing they have got, because in their affidavit, my lord.
We'll see. We'll look into the original record. Mr.
Now,
Kohli, you are having the record
yes.
pertaining to the Mr. Kohli.
Hmm.
Yesterday we had requested you. We
Lordship,
have the original record available.
of all the files, Lordship,
The files in which this decision was taken by the governor not to continue their
Yes.
services. We want to see that record.
Yes.
Lordship, I don't have that.
Whether,
But we have to see. Yesterday we indicated, we
Lordship,
didn't want the charge sheets and case diaries.
Yes.
We
Lordship,
don't need
that
those.
is my misunderstanding. I must say.
We never said that we want a criminal record.
No, Lordship, that's what I'm saying. This
What have
may be
we
my
got to do? We have
misunderstanding.
nothing to do with that. criminal
Absolutely, I'm saying it, Lordship, because when in the evening also when I was looking at it, I said, Lordship has asked these queries, we must carry all the record.
record.
I
We
stand
don't need
corrected,
that
Lordship.
record. We
And I'm saying it, absolutely.
All right, that record can be
It
presented.
can be brought, Lordship, absolutely.
Therefore, our humble, very clear submission is, my lord, if you have undertaken an exercise,
So, Mr. Chaudhary, let's wait for a while then.
yes,
Let's see the original record.
yes,
Let the court have a satisfaction
Yes.
what was looked at.
yes, yes.
Then we'll get back to you.
So of course, my lord, of course. My lord, if your lordship kindly permit, see one judgment I've already placed. I'd like to place that para once again, my lord. 2015, 15 SCC, page 151. My lord, that Ratnesh Kumar Chaudhary versus Indira Gandhi Institute of Medical Science.
What is the judgment?
A citation was, my lord, 2015, 15 SCC 151. Please come to, my lord, page 155, para 3 for the facts.
Yes.
When the appellant was continuing on the post of chest therapist, a complaint was received by the Vigilance Department, Government of Bihar on 3/11/2004 relating to illegal appointment of the appellant on the post of chest therapist. The complaint contained that the advertisement for physiotherapist and chest therapist were different because streams are different, and appointment of the appellant was absolutely illegal. In pursuance of the said complaint, an inquiry was conducted by Deputy Superintendent of Police, who submitted a report on 3/11/2004 to the Deputy Inspector General of Police, Bihar, Patna. Reports reflected on various aspects and pointed out that appointment was illegal. On the basis of the said report, Joint Secretary in the Department of Health, by order dated, requested the Director, Indira Gandhi Institute of Medical Science, to institute a proceeding for termination of service of the appellant by giving a show cause notice. On the basis of the said communication, appellant was asked by the Director to show cause within 3 days as to why, on account of illegal appointment, his service should not be terminated. The petitioner sent his reply on 23/2005 and asked for a copy of the complaint as well as entire report submitted by Vigilance Department. Despite the request made by the appellant, all the documents were not supplied to him, which the appellant considered vital. However, he submitted the reply on so-and-so. Director terminated his service by stating that the appointment on the post of chest therapist was illegal in terms of the investigation done by so-and-so. Now, my lord will kindly come to, this was the facts. Please come to para 27.
Yes.
After, at page number 166. After referring to all the case laws, my lord. In the case at hand, it is clear as crystal that on the basis of a complaint made by a member of a legislative assembly, an inquiry was directed to be held. It has been innocuously stated that the complaint was relating to illegal selection on the ground that the appellant did not possess the requisite qualification and was appointed to the post of chest therapist. The report that was submitted by the Cabinet Vigilance Department eloquently states about the conduct and character of the appellant. The stand taken in the counter affidavit indicates about the behavior of the appellant.
Behavior in service, Mr. Chaudhary. Behavior
Indicates about the behavior
during
of the
service
appellant.
period. During service
No,
period.
no, I'm coming, madam. It is also noticeable that authorities, after issuing a notice to show cause and obtaining a reply from the delinquent employee, did not supply the document. Read it as it may, no regular inquiry was held and he was visited with punishment of dismissal.
Yes.
It is well settled in law. If an ex parte inquiry is held behind the back of delinquent employee and there are stigmatic remarks, that would constitute foundation and not motive. Therefore, when inquiry commences and thereafter without framing of charge or without holding an inquiry,
We'll have to make a
delinquent
distinction.
employee is dismissed,
have read
definitely
it.
there is a clear violation of principles of natural justice. It cannot be equated with a situation of dropping of the disciplinary proceeding and passing an order of termination simpliciter. In that event, it would have been motive and could not have been travel to the realm of foundation. My lord will kindly come to placetum C. It was not an inquiry only to find out that he did not possess the requisite qualification. Had that been so, the matter would have been altogether different.
Yes, that observation.
The allegation in the report of Vigilance Department pertaining to his misbehavior, conduct, and his dealing with officers, and same also gets accentuated by the stand taken in the counter evidence.
Yes, Mr.
Thus,
Chaudhary.
by no stretch of imagination can it be accepted that it is a termination simpliciter. The division bench has expressed the view that no departmental inquiry is required to be held, as it was only an inquiry to find out necessary qualification for the post of sex therapist.
Yes.
Had the factual score been so, the said analysis would have been treated as correct. But unfortunately, the exposition of the factual matrix is absolutely different. Under such a circumstance, it is extremely difficult to concur with the view expressed by
So the allegations in the notice pertain to misbehavior, misconduct in service. That was the notice given, and decision was taken on a different ground.
That was not the only thing. Regular inquiry was held. That is what was said, my lord. End of the, my lord, let us come to the facts of the present case. There are serious allegations against us
Yes.
that we manipulated our appointment. And in that, my lord, even the chairman of the Public Service Commission was also guilty. My lord, to rebut that allegation, am I not entitled to a notice? Is that the principle of law, my lord? We are only
They've argued
Yes.
they've argued based on numerous judgments of Supreme Court
Yes.
that where the decision is apparent, the writing is writ large on the wall, that the decision will not change. There is no need of giving a notice.
Empty formality.
Yes, empty
No,
formality.
my lord. That principle as Supreme Court, with great respect, my lord, those judgments those are not in the realm of termination of a service of a provisioner. My lord, we were provisioner. So far as ACS service is concerned, as far as APS, our cases, our provision was over. Therefore, my lord, the rigors would be harder, more stricter rather. Now, the end of the day issue is, there are serious allegations. Based on these allegations, we are sought to be discharged from service. Are we not entitled to a notice? Are we not entitled to have a say in the matter? At least, maybe you may accept, you may not accept.
Give us one judgment on the same lines.
No, my lord.
Not find a single.
My lord,
In cases of scams, even there where there has been a separation of chaff from grain, therein also there were no notice. No notice was no right of opportunity of hearing was given.
The landed single judge has upheld the action of the government on two premises basically. First premise is, my lord, the police report could form the basis. And secondly, we relied upon judgments which do not pertain to, my lord, a pre-recruitment misconduct.
Pre-recruitment misconduct, yes.
All the judgments we referred was, my lord, it pertains to post-recruitment misconduct. But Palak Modi, we submitted, my lord. The landed single judge tried to, take a view that no, that doesn't fall in the list. There also a case where bank officer confirmation service was
confirmation. She was found involved in the confirmation test.
Yes.
Test for confirmation. So that was again misconduct in service.
Yes.
Not pre-recruitment misconduct.
No, my lord. That was the view taken. But my lord, the Honorable Supreme Court in Palak Modi's case made no distinction between pre-recruitment misconduct.
This was a misconduct while she was serving.
No, my lord.
She gave that test for confirmation, wherein there was allegation.
I'll place that judgment for a moment. Yes. I think Supreme Court never made the distinction, my lord. I'll just come.
Yes.
1 second.
Read the facts. What was the stage when that
I'm coming.
So-called misconduct was attributed?
Yes. Yes. Palak Modi is, my lord, 2013 3 SCC 607.
Yes.
I think paragraph 37 is the answer.
Read, please.
At page 633. 2013 3 SCC 607.
to give the compilation. It might be there in the judgment compile. It's Mishra's compile. Correct. Read the.
Yes, madam. The use of unfair means in evaluation test, confirmation test.
Confirmation test, that's what we are saying.
Yes.
That was a confirmation test. So it was a misconduct during the service period.
No, my lord. The Honorable
Not-
Supreme Court never said confirmation. Supreme Court never said that confirmation test was during the service.
Yes.
Can you have a look at it, my lord?
Let's see.
Para 37.
Yes.
The use of unfair means in the evaluation test, confirmation test held by the bank certainly constitute misconduct.
Yes.
The bank itself had treated such an act to be
Come to
misconduct.
para 2.
It is
come-
not in dispute.
Mr. Chaudhary,
My lord.
please come to para 2. There you will get the answer.
Yes. No, on the facts, my lord.
Yes.
Yes.
On facts, para 2.
Para 229.
611. Palak Modi.
No,
Para-
but I am having the relevant extract only.
No, para 2
Anyway.
is relevant.
No, my lord, the finding is para 37, my lord.
Please
Anyway,
read para 2.
I've taken note of para 2, my lord.
Para 2 says the selection was made on 5/5/2006
Yes.
as a probationary officer. Then there was a requirement of satisfactory performance in evaluation tests to be conducted by the bank
Yes.
during the probation period. Therein, the candidate was found involved in fraud.
There
So
is
that
no-
was in
no,
service.
There is no dispute, my lord, that he
Yes.
was on probation and that particular test. But in para 37, my lord,
Mm.
if your lordship will kindly see, Supreme Court has not carved out that distinction. Please see, my lord.
Mm.
Use of unfair means in the evaluation test, confirmation test held by the bank certainly constitutes a misconduct. Bank itself had treated such an act to be misconduct. It is not in dispute that the service of the private respondents were not terminated on the ground that there was any deficiency or shortcoming in their work or performance during probation, or that they had failed to satisfactorily complete the training, or had failed to secure the qualifying marks in the test held on 27/2/2011. As a matter of fact, note prepared by the Deputy General Manager, which was approved by the General Manager, makes it crystal clear that decision to dispense with the service of the private respondent was taken solely on the ground that they were guilty of using unfair means in the test held. To put it differently, the foundation of the action taken by the General Manager was accusation that while appearing in the objective test, the private respondent had resorted to copying. So, my lord, his ground on which he was never done nothing to do with his conduct as an employee probationer. The entire allegation was the bank's perspective was he is guilty of adopting unfair means in the test.
Okay. very-
That is pre-confirmation, my lord.
Yes.
So therefore, my lord, in these facts, this honorable Supreme Court says that it again constituted misconduct, therefore it was foundation, therefore 311 is attractive.
Mm.
So, my lord, to say that therefore the learned single judge is in error, my lord, in coming to the conclusion that the honorable Supreme Court never made any distinction between the two. No, it's same, my lord, whether it's once it is a misconduct, it is a misconduct, whether at a pre-recruitment stage or a post-recruitment stage. Therefore, my lord, that's why I'm saying, my lord, the records will be very necessary in this case,
We'll
because
see.
records must reveal that it was during the process of evaluation or finding out whether I'm suitable or not if the decision is taken, then
That
it is
we
otherwise.
have asked them to produce the
Yes,
records.
therefore,
By-
my lord.
There was some confusion.
So, my lord,
So they brought the
having-
case diary as a matter.
so otherwise, I'm repeating my argument, my lord. My humble submission is therefore, therefore, the learned single judge is in error in coming to the distinction that exists purportedly between a pre-recruitment misconduct or a post-recruitment misconduct. My lord, as far as Supreme Court is concerned, Supreme Court has not made any such distinction. Once you take note of a misconduct, whether at the pre-recruitment stage or a post-recruitment stage, it will be foundation. And once it is foundation, 311 will be attracted. At least, my lord, I am entitled to notice, my lord. How can they deny that? These are only realm of allegation until it is proved in a court of law. My lord, one judgment, my lord, that I did not place on the opening ray. Yes. If a lordship would kindly have 2014 9 SCC page 1, Manoj Narula versus Union of India. Yes.
Yes.
2014 9 SCC page 1. Para 121 to 123. Oh, book list was also given, because-
Didn't you give the list in
Yes, my lord.
advance?
Book list, originally it was given, my lord.
Okay.
2014 9 SCC page 1.
No, this is inside.
14 9 SCC page 1. नहीं सर किताब में रखा नहीं गया
What is the ratio? Please read.
The ratio is, my lord, law does not hold a person guilty or deem or brand a person as a criminal only because an allegation is made against that person of having committed a criminal offense, be it in the form of an off-the-cuff allegation or an allegation in the form of a first information report or a complaint or an accusation in a final report under section 173 of the CRPC, or even a charge framed by a competent court. The reason for this is fundamental to criminal jurisprudence, the rule of law, and is quite simple. Although it is often forgotten and overlooked, a person is innocent until proven
That's
guilty.
for in a criminal trial, Mr.
No, well, other generally, not in the context of criminal trial.
Principles you are reading relate to a criminal trial.
No, my lord, when a person, there is an allegation against a person, now the man is to be treated as what? That is the issue. Against us, as of date, there are allegations only.
You are not being convicted on those allegations. You are being given a fair trial. So before putting you behind bars, you will be given a ample opportunity.
But whether then
Yes, yes.
Please come to page 64, my lord, page 122. Law does not hold a person guilty or deem. The law does not hold a person guilty or deem or brand a person as a criminal only because an allegation is made against that person for having committed a criminal offense, be it in the form of an off-the-cuff allegation or an allegation in the form of first information report or a complaint or an
That is for the
accusation in
purpose
final
of
report.
being elected to the parliament.
Yes.
That mere pendency of trial will not be considered to be a ground to depart them.
True. Then my lord will kindly come to page para 123. The parliament has therefore in its wisdom made a distinction between an accused person and a convict. For the purpose of election law, an accused person is as much entitled to be elected to the legislature of so and so. But parliament has taken steps to ensure that at least some categories of convict, because in the context of RP Act. So my humble submission is, my lord, on the day when we were discharged, all that was there was the police report, where certain allegations are there that we adopted unfair means to get selected to this service. My lord, those allegations were never confronted.
Beyond unfair means blatant fraud, that is the allegation.
Whatever expression one may use, those are, but still it is in the realm of an allegation until and unless it is proved. Neither there was any administrative inquiry, there is nothing. Only police record, police report based on which, my lord, we are discharged. And this is so because the state has, expressly stated in their affidavit. In the affidavit filed by the state in paragraph 7, my lord, the unequivocal stand is the action we have taken because of the police report in Dibrugarh PS case number so and so. Now the issue is therefore, that means certain allegations has been taken note of. Now when the allegations have been taken note of, whether it would be a termination simpliciter or it would be a punishment. If it is a punishment, my lord, right from my lord Purushottam Lal Dhingra, Shamsher Singh and all the line of cases, my lord, there is a requirement of a notice. So that has been denied to us. Well, the government is not deprived of any opportunity, my lord. They can still undertake that exercise. It's not that, my lord, if supposing if a lordship interferes with the action taken by, that doesn't mean, my lord, we will go scot-free. The liberty can always be given to them to proceed in accordance with law. The question is the procedural safeguard, which were otherwise entitled to under, my lord, Article 311, whether that can be dispensed with in the manner as has been done in the instant case. More so when we are provisional, more so when no exercise was undertaken to find out whether we should be, we are found suitable for retention or not. On the contrary, there were allegations. Taking note of those allegations, my lord, were discharged. And I think the judicial preponderance of judicial view in my humble submission is, my lord, that in such a situation, it has to be construed as a punishment, and therefore, my lord, 311 or at least rules of natural justice is applicable. And as far as the Assam police is concerned, my lord, I have already submitted similar argument. Only thing is there, my lord, according to us, we completed our probationary period.
There are a number of judgments which have been cited that unless there is a specific order of confirmation, you can't be treated to be confirmed. That will be a deemed continuation of
My lord,
probation.
that lordships will
Number
take
of
note of that.
judgments. Yes.
And my lord, if they want to extend our, probationary period, then also there is a requirement of
They don't want, they say that it is a deemed one. Till that it continues 4 years, they can do it under the rules. And even beyond that, that's what the ratio of the judgment cited is.
My lord, finally, one paragraph from Purushottam Lal Dhingra, para 28, that my friend Mr. D.K. Mishra must have placed it, my lord.
Yes.
I'll just read para 28 once, my lord. AIR 1958, Supreme Court 36.
Yes.
Para 28.
Yes.
The position may therefore be summed up as follows. Any and every termination of service is not dismissal, removal, or reduction in rank. A termination of service brought about by exercise of contractual right is not per se dismissal or removal, as has been held by this court in so and so. Likewise, the termination of service by compulsory retirement in terms of a specific rule.
Yes.
Specific rule regulating the condition of service is not tantamount to infliction of punishment and does not attract Article 11(2), as has been held by this court in so and so. In either of the two above mentioned cases, the termination of service did not carry with it the penal consequence of loss of pay or allowance under Rule 52 of the Fundamental Rule. It is true that misconduct, negligence, inefficiency, or other disqualification may be motive or inducing factor which influences the government to take action under the terms of the contract of employment or specific service rule. Nevertheless, if right exists under the contract or rules to terminate the service, motive operating on the mind of the government is as Saglas is as in so and so wholly irrelevant. In short, if the termination of service is founded on the right flowing from contract or service rule, then prima facie the termination is not punishment and carries with no evil civil consequences so far as Article 311 is not attracted. But if the government has by contract or under the rules a right to terminate the employment without going through procedure prescribed for inflicting punishment of dismissal or removal or reduction in rank, government may nevertheless choose to punish the servant. And if the termination of service is sought to be founded on misconduct, negligence, efficiency, or other disqualification, then it is a punishment and requirement of Article 311 must be complied. The moment, my lord, it is founded on misconduct, my lord, whether it is pre or post, my lord, then 311 is affected. That is our only case, my lord. We are only assailing the decision-making process. Our case is, my lord, the manner in which our right has been dealt with. This is not consistent with Article 14 and 311. And therefore, my lord, the lordships will interfere with the order of the learned single judge, as well as the, my lord, order of the authority whereby we are discharged from service.
Yes.
And nevertheless, lordships can reserve the liberty of the state to take necessary action in accordance with law.
Arguments Stand conclude, yes.
Just one clarification, Lordship, which is I'd mentioned to two scouts specifically. Navakanta Patel is a confirmed employee several years ago. He's not one who has sat
So
in the
he's
examination.
beyond any disciplinary
No,
proceeding.
Lordship, not at
Then-
all. That he's also been charge sheeted, Lordship. All that is happening. But what they are trying to say that he's on equal footing. He was
First
not-
perpetrator of the offense. Till date, have you taken any disciplinary action? Let us know tomorrow.
Yes, Lordship.
Let's know tomorrow. Yes. All right. Arguments have been concluded by Ms. Kohli. Ms. Senior Counsel, Ms. Mishra. Request is made on behalf of Mr. Senior Counsel, Mr. Mishra, and by Senior Counsel, Mr. Das, to post the matter tomorrow for rejoinder submissions. Submissions and rejoinder. Mr. Kohli shall keep the original records pertaining to the decision-making process whereby, the appellants herein were discharged, purportedly discharged, available for the court's perusal tomorrow.
May I, Lordship, make one submission, not with this? Lordship, it seems in the plethora of cases, this one, as Lordship pointed out, our reply has been not filed in the one with regard to this. Lordship, it's not part of the pleadings. It seems to have happened between, and I have to be responsible for it. Lordship.
Pleading is there in appeal.
Yes,
Maybe
Lordship.
we have admitted the appeal.
Lordship,
So
I was only seeking Lordship's indulgence, at least
can find
whatever
short
we've
evidence.
argued, we'll put it on record, at least, Lordship. The pleadings will be.
Do that tomorrow morning.
Yes.
Let Ms. Das, let the response to this pleading come. Yes.
And he said that there is a sufficient material fact that he has not brought this pleading. He wants to say that.
No, he wants to respond to your submission regarding that 9-page list. In the interest of justice, we hereby permit Mr. Kohli to file affidavit in response to certain submissions made in writ appeal number so and so, which seem to be over and above the submissions which were advanced before the learned single judge. Presumably because certain facts have come into existence at a later point of time. Existence of the knowledge of the parties. You say that these facts came to light later. That's what your case is.
I got 2 pages, I will just complete with a small affidavit, 2 orders, that you are also kind.
Orders of what nature?
They just to show, my lord, it is a confirmed, they are confirmed, my lord. They are confirmed employees of APSC. That you are also kindly allow me.
We are reopening the entire process.
My lord, 2 orders.
All right. Mr. Das also prays that he may be permitted to bring 2 government orders on record with affidavit.
We'll take
He
a
may do
copy,
so after providing copy to Mr. Kohli.
and we'll respond in our affidavit.
Yes.
So will you be able to do it tomorrow, or you want to do it day after tomorrow?
If Lordship would give us day after, I'd be very grateful, but if Lordship says tomorrow.
You have to enjoy Guwahati weather for
No,
2 more
Lordship,
days.
I'm rushing to the office to collect the files.
Okay.
Because Lordship, they have
So
gone
then
into.
day after tomorrow, perhaps day after tomorrow.